And the respondent wife.
Where is the husband?
Last occasion, your lordship has issued notice, my lord, that I have filed the requisites. It says from the cause list that
Make use of the mic.
order dated 13/2/26, my lord. Lordship was directed to serve notice on the appellant.
Notice is served on.
Yes, my lord. It seems from the cause list that two of the lawyers are appearing. The name is indicating.
Whether whether notice is served. The earlier counsel have given my consent to other side has to come, na?
Yeah.
Other side is not here.
Not here.
No. The notice is not yet served. But they have appeared. Without service, how they will. Anyway, they have appeared, no? They have appeared. Any interim order is required in the matter?
No interim, only rest 12 lakhs of rupees, including interest, has not been paid since 2023.
Not paying. That money he is not paying.
No.
Where is your application? Show that. What is he? What husband is doing? Sir, where is the order for making payment?
Lordship, 25/8/23, order number 5.
Order number 5. What order? This was dated 25/8/2023.
23 million.
Even then he has not paid.
Paid 12 lakhs million pursuant to that order, and rest 12 lakhs have not.
$12 is paid on which date?
IA number 130 million I have filed in 24.
Questions. They are asking why. On which date they have given that 12 lakh?
Only in the IA, my lord, I have said in 2 occasions 7 lakhs, 5 lakhs.
7 is paid on which date?
Date, in fact, I have not written out in paragraph 3. IA number 130 of 24, I have said that. And I have received. Yes, my lord. The date.
That can also know the date.
12 lakh is paid now, as of now.
Yes.
Another 12 lakh
12 lakh has not been paid.
Where is the order for 24 lakh? It is mentioning 17 lakh, no? Show the order where 24 lakh is ordered to be paid.
That order, my lord, 25/8/23, my lord.
Order number?
Order number 5, my lord. That has been confirmed by this honorable court.
Where it is said
Where my lord Justice SAHOO, I think, part of this.
the whole amount shall be released in cover showing the one in a period of 3 months. Hence, years 2024 October 2020 installment 6 lakh. Second installment is another 6 lakh. And another is 5 lakh.
Not
665.
That's
It is 17 lakh. Why do you say 24 lakh? Why you are mentioning 24 lakhs, sir?
Payment of 7.
7 is already paid. But now remaining amount is 70 is paid. Another 7 lakh is payable. 7 is paid. 7 is paid. So what kind of advocacy, sir? You do not know what is the amount paid, when the amount is paid. How you are going to protect the interest of that poor lady?
7 lakhs paid on 23/8/23, my lord.
Huh?
7 lakhs was paid on 23/8/23.
23/8/23.
23.
Then remaining? They don't read. There is no reading habit at all.
6 lakhs by 4th October 2022.
6 lakhs on
6 lakh 5. 24/9/2022.
9/23 and remain another 6 lakh.
Another 5 lakh.
What is another 6?
Sorry, 6 lakhs 24/10/23.
24/10/23. So 19 lakh is paid.
Then 5 lakhs 24/11/20.
24 is paid now.
Direction is this. So he had paid by the direction issued, he had paid 7 lakhs. Then 5 lakhs he has paid after 7.
After 7, 5 lakhs.
So 12 lakhs remains.
Lordship.
But
7, 5.
we are not sure from your reports. This I have got confused.
The lower court has allowed me lot 24.
24 is
24 lakhs.
7 plus out of this first installment, second installment, he has paid 5 lakhs. Beyond that, he has not.
Out of
24.
out of 24
7 was paid
earlier.
earlier.
So it comes to 17. Then of that,
5
24/11/23, 5 lakhs.
after he has paid.
another 12 is remaining.
Two drafts.
Default
Two
was
drafts are
8% per annum. Anyway, you can take care of it.
That's what is he doing? What the husband is doing?
Now, my lord is retired, perhaps he is not there. No address, nothing.
Where from he has taken?
No, that is also not there, my lord.
Retired.
From the place, my lord, from the place I have ascertained that that person is not there.
We don't know. Because your knowledge.
Because once
One
notice,
specific instruction because he has retired. Where from he has retired?
What he retired?
What he retired?
What are the emoluments drawn?
Something or you can ask ready to farmers or appraisers.
that is on last occasion, my lord.
Jerry, do that.
That's
Call tomorrow.
Lordship tomorrow. Because last occasion, my lord, last occasion another lawyer has appeared, my lord.
Why? Not let the.
Yes, my lord.
Inform the other council.
No, if we send the arrest warrant, everything is. Yeah. Tomorrow.
Please help us.
You have to come with preparation of that.
Talk to the lady. What amount when she has received, she will be aware. He will give you the instruction.
Yes.
If you know the office, you can ask the government council or the Union of India, so they will trace him up.
Right now, right. Learned counsel appealing for the wife submits that out of a sum of 24 lakh rupees payable in terms of order dated 25/8/2023, including the 7 lakh already paid, the council submits only a sum of rupees 5 lakh has been paid on 24/11/2023, and that the husband is not paying the remainder with no justification whatsoever. First time. When the case was called out today, the learned advocates appearing for the husband are absent, and there is no otherwise representation also. First time. To give a last chance, call this matter tomorrow. And I took it well. No, part of the bar. And
Next till date.
by way of coercive action, the arrest and detention of the husband may be ordered tomorrow. Yes. So that then we can take.
Please, my lord. My lord,
Yes.
as per the notings, the notice has returned unserved saying that there's no such person, my lord.
So, the lady,
Yes, my lord.
mother's paternal place, or brother's.
My lords, this is the second address which we had tried to trace out and notice was sent. My lord.
Fresh steps in respect of answered respondent within 1 week.
My lords. And my lords, I may be permitted, in case if we cannot trace out the address, we may be permitted to serve a copy to the council appearing in the matter.
Apart from the this was concerning counterpart. Counsel is there. Oh, what he will do? Now that matter is over.
My lords, I bow down, but if he may be in contact with the client, my lords, because we are not being able
It
to
is
trace
open
that.
to the appellant, review petitioner.
Yes, my lord. Review petitioners.
To seek whereabouts of the respondent. So, OP or respondent? OP. At the hands of learned advocate who represented her in the court below. Okay.
It's in the appeal.
In the appeal.
My
In the appeal. Okay. Okay.
Obligation, my lords.
May I please, your lords?
Yes.
The petitioner challenge the order dated 22/6/2017 by the State Administrative Tribunal, as the tribunal has hold the view that
If I may interrupt your lordship, on the last occasion, in 2024, it filed, the Honorable Court had asked him to get the original letter where his sports has been sanctioned, approval of
Not-
the original letter.
date of
Now
trial.
that he couldn't get, but he's
But-
filed an IA and the court has directed the state to procure that piece of
Order.
information. That, your lordship, I need some time, your lordship, because this has come after.
One second, kindly be seated.
That
When
or-
that order was,
that order was passed in the year 2024, your lordship.
how much time are you going to arrange? to
This has
take that
come
order?
after that, your lordship. So I've not been able, just 1 or 2 weeks time may be given, your lordship. I will file an affidavit to that effect. Whether that letter of approval is there or not. Because as per our counter, we had done an enquiry in the year 2009. And in that enquiry, it was found out that he has not worked, your lordship, there. His name is not there. The students don't know of him. And he was never appointed against a sanctioned post. There was no approval to his post, your lordship. That has been found out in the inquiry.
The request of learned EPA, madam, finally, 1 week is granted for producing the copy of the order in question,
If
if available. First,
All the stakeholders. Answer to meeting.
yes, sir.
I said they don't understand what that is.
well up to two. Yes,
Obliged, your lordship.
on the next date of hearing, some stringent orders may be passed against the hearing officials. Noted. Next. Yes, sir.
I'm on the behalf of Mr. Senior Advocate Durga Prasad Nanda. As he is out of station, therefore I pray for his attention.
Call of 2 weeks on the ground of inconvenience of the arguing counsel, so it's not available today. Okay.
May I please, lordship? The single judge order, then writ appeal, then contempt, and then SLP. SLP also dismissed. They,
Copy. Of the copy.
Yes, yes, so we have got it.
Also that.
yes, yes, madam.
Dear Mr. Misra was addressing us. Thank you.
Yes, we have gone through the affidavit. Actually, no partial compliance. They will say that they are partially compliant.
What was the order?
Order your lordship kindly see. Order your lordship kindly see. The single judge have categorically said that the post they are holding a perennial nature, and your lordship has confirmed it that your lordship page look at page 25.
25.
Page 25. My lord, sorry.
In the sense, but the not a single judge has not defined any post giving a finding on the post. He simply said that the post they are holding is present.
Yes, but that.
Which post they are holding? Nothing.
Well, that is there on record. That is there on record. In the writ petition, there is on record. I'm also today I'm filing affidavit.
So now if they are giving a post,
My lord, they are given a post, my lord. That doesn't mean that this has to be strictly complied with the letter and spirit. Honorable Supreme Court has said, lordship has even that the judgment has to be implemented in letter and spirit. Letter and spirit, the person, different they admit that yes, these persons have been working as clerks or some other post, my lord, and they have document. Yes, my lord, that is.
so from the current single judge order and the interpret order where they have wanted the post.
No. Honorable single judge have not specified the post, but they say that the post they are holding, and that what post they are holding, that is then part of the record. That is part of the record post that admitted post.
Based on the fashion.
No, ballot, that way, my lord, that way there is no end to litigation, my lord. There is no end to litigation because this way, my lord, sorry, my lord. Sorry, my lord.
Credits in the content.
No, I'm not saying that. I'm not.
You are all done by the.
Yes, my lord. I'm conscious of that, my lord. I'm conscious of that, my lord. I'm conscious of that. That your lordship will not enter into merit of the case. I'm conscious of that. But my humble submission is that it has to be uploaded in letter and spirit. And letter and spirit, your lordship will see from the honorable single judge order, lordship can see page. Page
Number?
The read petition.
Yes, the writ petition. That is there in the writ appeal also. The single judge order is there in the writ appeal also. And they had recommended, the board has recommended to the government. Sorry, my lord.
See show the order.
My lord, yes. My lord, that is at page 26, my lord. Page 26 of the writ appeal, my lord.
The internal page of the paragraph.
Your lordship can you see the last para 6, my lord. Your lordship
This court directs.
furthermore, this court directs that while considering the case of the petitioner, regulation of opposite parties shall also keep in view the order passed in WBC number 200, which has been confirmed by Honorable Supreme Court in an appeal filed by opposite party number 200. And they, in that case, my lord, they have given appropriate posting. In the Honorable Supreme Court, while dismissing the appeal of the Swaraj Board,
Since 3921.
3921, they had given them appropriate posting. Wherever the post is. Sorry, my lord.
Which post?
The two posts, which post they were working, the post, they have been regulated in the post. Some are clerical, some are group D posts, like this, my lord. My lord, dear lordship kindly see, on a careful analysis of the factual backdrop of the above noted case, it appears that the facts of the present case are almost identical to the facts of the opposite case. In such view of the matter, the opposite parties are directed to consider the case of the petitioner for regularization of service in the light of the order passed by the coordinate bench referred to in the above, which has been confirmed with the Honorable Supreme Court within a period of 2 months from the date of communication. Then, my lord, para 7, my lord. A little bit, it is further directed that while considering the case of the petition, regulation of service directed herein, the opposite party cannot reject the claim only on the ground that there is no sanction post. Further, it is directed that in such event, the opposite party shall take a decision with regard to creation and sanction of post to observe, regularize the petitioners. In the event of such decision is taken pursuant to the aforesaid direction, the same request concurrence of state, the state opposite party shall consent the grant of concurrence, keeping in mind that petitioners have been working for more than 2 decades and such the nature of work they are performing at perennial in nature. And your lordship in division means also, your lordship have also referred to the page 56, my lord. But your lordship have also referred to the fact that they have themselves recommended to the government for creation of post. The purpose of recommendation is to observe the persons like the petitioners. That is the reason today I am also filing affidavits showing those documents which are there part of the record. Your lordship kindly see page 56. Page 56 the writ appeal.
There is a
Content application, my lord. Sorry, my lord. Your lordship. Your lordship, continue.
there is a direction for creation of force
Yes.
in the learned single judges order. There is a direction for
Yes,
creation
yes,
of force.
yes.
Where have you created?
Para 7.
No. Where have you created the force?
My lord, what I wait to submit, my lord.
You sent a proposal to the government.
My lord, board.
You are for who?
My lord, I am for the board, my lord.
Board. Who creates the force in the board?
My lord, board has given a proposal, government has to create it.
In which section?
Section 9, man.
Read out. Which act it is?
OWC Act, my lord.
Which act, which statute, which enactment?
That is Orissa Water Supply Board Act, my lord.
You there. For creation of which post you have made the proposal? What post?
Lord, as per the compliance order, my lord. My lord, I have mentioned all the documents are not with
We
me.
are asking a specific question. Have you sent proposal to the government? Yes or no?
My lord said.
Sent. Which post you have sought for the creation of?
I request my lordship and see my memo file.
We will not see anything.
No, my lord,
It
that
is
is
a
there.
2-minute case.
That is there in the record, man.
Therefore, no, we want you to tell them why the lawyer is necessary if everything is to be record. We are asking you,
My lord.
which post you asked the government to create?
May Group D postman.
We are asking you.
Yes.
Anybody can answer.
Group D postman.
Group D post. When you had to send it?
My lord, that is on 1/6/26, my lord.
1/6/26.
My lord.
After the content proceedings were initiated.
My lord.
Under which section? You lost one? After they lost. No, even after they 1/6/26. Which section required for the creation
Section
of
9,
the
ma'am.
post? The government has to take the decision.
Section 9, ma'am.
Read section 9.
Appoint such officers and employees as it considers necessary for the efficient performance of its duties and discharge of its functions against work sanctioned by the state government.
So posts are sanctioned by the state government.
My lord.
1/6/2026. Whether state is also a party here?
Yes,
Yes, my lord.
Who appears for the state? What have you done with the 1/6/26 proposal for creation of support? How long they should go on fight the? They will go on fight this. When the post was created?
My lord, for a moment, I am what I am saying. I will reply my lord's question. Against my lord's common judgment dated 30th July 2025, there are 11 SLPs filed with the Supreme Court. So when the Supreme Court has dismissed all the SLPs, we
On which date?
on 2/26, man.
2/2/2020.
On 2/26, the Supreme Court dismissed all the SLPs
Yes, sir.
and directed that the content proceeding before the Supreme Court shall not be worked out. The additional Chief Secretary of Answer and Union Department filed an affidavit of undertaking before 19th February 2026 to comply the orders and regularize all.
Yeah.
Accordingly, the affidavit was filed on 19th February. Thereafter, there was some delay on extension application had MA number so and such filed for extension of time. This matter was taken up before the Supreme Court on 26th.
Whether extension granted or not?
Granted, man.
Say that one.
26/5/26, and this Honorable Supreme Court directed to regularize and as per the compliance affidavit undertaking by within 11 days from 26/5. Accordingly, on 3/6, we have filed affidavit before the Supreme Court, and Supreme Court monitoring the matter, and the matter has been posted to 13th July 2026.
No, posted before the apex court.
Yes, my lord.
It is
Therefore,
posted.
last
We'll have it after 13.
And since you are very clear, you stand that you are never worked in Group D, And they have asked for group D and group D has been created. Take this stand before the Honorable Apex.
Yes, my lord.
Well, they are appearing.
What?
They are appearing before the apex court. Sorry, man.
That is not.
No, sorry. I'm sorry, man. Sorry. My appeal, sorry.
I don't know what.
No, my lord.
Yes, my lord. I am obliged, my lord.
What we have in the Supreme Court. Learned counsel Mr. Hon'Ble appearing for the contender number,
OP number 2, my lord.
OP or contender?
Contender number 2, sir.
Contender number 2 submits that after the challenge to the DP order failed, and pursuant to the direction given by the apex court, the proposal has been sent on 1/6/2026 for creation of posts of group D posts. Group D posts. Not correct.
Previously,
We are not disposing of any matter.
My lord.
We are just giving
previously
grounds
they
so that
have sent recommendation for creation of class 3 post and group C post and group D post also.
group C and group D posts.
My lord,
What they have sought
my petition is a group A post, my lord, to
for?
Sarpanda.
Which post they had sought for
Yes.
creation.
Group C and group D.
Is it true? Group C is also true.
What you are
Yes.
saying, they
They are
have
not
sent for group A.
Yes,
They
that,
say that.
this is the letter I just want to show, my lord.
Following, that's the problem. I don't know what has happened. So, Mr. case is that they have sought for creation of group C, group D. So you are differing with Mr. Mishra?
Yes.
You
I am a group A post.
Whatever you may be,
What was sought for?
which posts were sought to be created?
Group A post.
Group A?
Yes.
Where is your letter?
Yes.
Give that.
Can see it. The 2020 letter.
Not 20. First
Yes,
is the
yes.
order of the apex court.
Since you are.
Your lordship may see apex.
Not the appeal council, you are not following it out.
This we will not look into. This is of
You don't
2020.
understand actually.
This is
You are
of
thinking that
2020.
directing something against you, no. The context is different.
So simple. We are all wasting time on the
My
1 minute case these are. Which posts were sought to be created? You don't read the paper.
C and D.
Show me which posts you have.
my lord, what is the great respect to my lord senior? My lord,
Stop comment. Mahapatra, may I ask you your permission? Your submission should be no post has been transferred to be created in group A.
yes,
Correct? Am I correct?
yes,
So that should have been your submission.
yes.
Now that we will look into. Which posts were, again, we are asking you.
Well, I'm,
Which posts were sought to be created by order, letter dated 1/6/20. Where is your letter 1/6/26? Read from that and tell us. You read and tell, we believe you.
my lord, in compliance with the orders of the Honorable Supreme Court of India in miscellaneous application in SLP no so and so, and the Honorable High Court of Orissa in accordance with clause 9(1) of Orissa Water Supply Storage Board Act 1991, reducing clause 21 of the OWC Regulation 92, and pursuant to the decision taken in 28th board meeting of OWC held on 26 to 20
Sir, go to direct creation of, where is the request for creation? Read other story we do not need. We are asking which post. Read that one, which post?
But that is not specifically mentioned in this letter, man.
Then how government will create? Which post government will create?
Because here they have mentioned it, they have group D post, my lord. But they have mentioned here, the services are the following DLR, consultant workman, or WSA in supplemented supernumerary group D post in the pay scale of 16,000 so and so.
So group D post you are sought for.
Short for man.
Mr. Mishra said it's a
Well,
A and B.
that was-
C
that
and
was-
D.
that-
On what basis?
Well, that was earlier they had, when the during course of the writ application, they had, the document was filed wherein they have recommended to create the post of group C and group D.
Both.
Yes, both.
Which is that?
That letter, when the,
Kindly. Very good, my lord. After they ordered to people the apex court that we are going
No,
to
no.
do it. After that, they started a process.
huh,
So they sought for creation of posts. So there, what has happened? So maybe they have not also sought
that
for.
copy they have not given us. That copy they have not. I am,
So maybe-
my submission is based on the recommendation which they have made earlier.
Maybe because after undertaking before Supreme Court, they have not sought for creation of group C. So
That I do not, because that document is not there with us. They have not given.
They are in the writ application.
Thereafter, they have,
Because what Mr. Mahanti said that they have taken steps and they have
That is true, that is
after
true.
failed in Supreme Court and 1/6 they sought for creation. So there we are stuck. That which road they wanted to create, because then the government has created or not.
Then
whether it has been
we
public-
will also place our case before the Honorable Supreme Court because
We are told that the matter is posted before the apex court on 13/7/2026. First now, call this matter in the last week of July 2026.
my lord, may I pay before Lordship on 15th, 13th, before Lordship. We want the matter to be taken up by your Lordship only.
Will come.
15th, 13th, they will, the 13th order will pass to 15th Lordship again.
Let us know.
Deeply placed.
In pattern. To make a mention, thus unusually I'm making a mention that single page matter before the division page matter. It's a logic matter.
Pardon, let's say item number 15, permit to
15. Let it reach, we'll see.
And item 25.
Ah.
Remember that giving the benefit to the person who is appearing in the railway matter. We have given all benefits, promotional letter. Part of the amount is already.
Oh.
No, person, another person.
25.
Yes. Portion they were filing the affidavit, let's keep it next. Today I will filing affidavit as regard to compliance of this portion.
When you want.
Next week is there. I personally, whatever we have transferred, another whatever balance you transfer will have accepted.
Learned EST Mr. Fadi submits that the order in spirit and substance has been complied with, and an affidavit of compliance is being filed.
Today itself.
Being filed. First, for that he seeks a short accommodation. Call this matter on next 16.
60, yes.
16. Yes. Holiday. 15th only.
Yes, 15.
On 15 for reporting compliance. Non-compliance will be viewed very seriously, and an order for arrest and detention of the non-compliance of the persons who do not comply the order may be ordered, may be directed.
We are satisfied that the punishment of compulsory retirement imposed upon the petitioner is disproportionate to the misconduct abuse and cannot be sustained in law. Although we did not appreciate the conduct of the petitioner vis-a-vis his management, still, having regard to the nature of the disciplinary action which has been taken against him, being not proportionate, the order has been set aside.
Yes. Next.
For judgment, item number 2, interpret 1359 of 2025.
Yeah, and for the applicant.
Yes.
We have considered all aspects of the matter in the light of provisions of Act 2004 Act and 2005 rules. We have referred to an American Supreme Court judgment. The long last we have said like this. In the above circumstances, this appeal is allowed in part as under. The impugned judgment, to the extent it upholds the letter dated 18/10/2024 challenging the writ petition, is sustained. Liberty is reserved to the appellant to submit the appropriate proposal for alternate land in terms of letter dated 18/10/2024 within a period of 3 weeks reckoned from this day. A writ of mandamus issues to the respondent numbers 1 to 7 to process appellant's claim at various stages for alternate land within an outer limit of 3 months, subject to all just compliances. The culpable delay attributable to concern of the respondent shall be viewed very seriously in the next level of legal battle, and heavy costs may be levied personally payable by the hearing officials. No costs.
Deeply obliged. Well, it's just one request. Instead of 3 weeks, your lordships, they provided, could it be 4 weeks? Because it will take identification of that process.
And within 3 months, they have to do everything.
I'm so grateful, Millets. I once again convey my gratitude, Millets, for your lordship's time, Millets, that your lordships
argued that matter so passionately. We appreciated by myself and my brother.
So grateful.
Yeah.
Lordships, if I may say, my name may be reflected in that. I love for the appellate along with Mr. Acharya.
He was assisting me, Millets, in this matter.
The way you argued, the notes you had given, really wonderful. Wonderful.
Grateful.
Highly obliged.
Number 4, Republic 177 of 2025.
Please, your lordships. Your lordship, in this rate appeal, the appellant is actually challenging a DP that has been initiated against him, and he was working as a police inspector because of an inadvertent mistake after a span of 6 years and 2 months. Basically, the cause of action arose when the appellant arrested one accused Ramakanta Naik on 24/2/2019 for the allegation that he, along with 2 other accused persons, committed theft on 11/11/2018. But
He was in custody.
in that period, in that span of time,
What kind of order by the learned single? Can you see? Since the present writ petition has been filed challenging initiation of the department proceeding, this court is not inclined to interfere. In it. Challenge is on various grounds. Where is the treatment of the subject? No, we don't agree with this kind of approach. This is for admission.
Admission.
I heard a learned counsel appealing for the appellant delinquent employee. First time. She suggests that the reasoning provided at para 3 of the impugned order dated 24/11/2025 is strictly, to say the least. First time. A prima facie case is made out for issuance of notice. First time. Issue notice. Learned AGA Mr. G is requested to accept notice for the office.
For the whole of this.
First matter lays in a narrow compass, and therefore push this matter of police.
so Your Lordship, I filed an IA for the stay of the disciplinary proceeding because
No, my lord, because he has shown in the he was arrested a person who is in custody prior to the date of arrest.
Your Lordship,
That is the allegation against him.
the appellant was unaware of this fact, and because he has a series of criminal antecedents and
the person who is arrested.
So
The person who is arrested, he is in custody, but he has shown that
But he never-
that date of arrest, on the date of arrest, the accused in custody.
but when he was forwarded to the
What the
magistrate,
misconduct he has committed.
but when he was forwarded to the magistrate and also to the arresting officer, he did not disclose that he was in the custody, and just acting
On the date
in
of
good
incident.
faith, he arrested him.
On the date of incident, he was in the custody. That is what
How could he attend?
You-
When he is inside.
When inside the custody.
So he-
Yes.
he-
Let us see. The application for interim protection would be
Yeah.
considered
Your Lordship,
after the other side finds its objections there. Okay. Yes. Yes.
Anyway.
Five.
Under Annexure 1, your lordship, the petitioner as being the loanee of the bank issued a notice of overdue amount of 8,18,570, your lordship, after 76 days of overdue. My grievance, your lordship, limited grievance, your lordship, my representation will be disposed of by the bank. I'll pay all the amount of overdue amount 76 days.
You pay.
Yes, it is.
Why
with the
representation?
other
Why give you that order now? You pay that money.
Because why I am saying only 76
Why
days
bank
of.
should consider? Whatever bank can do, it court can do. We will consider it now. You make the payment, we'll tell you.
Yes, sir, I'll. Of that overdue. Not of that overdue amount where they says that 8 lakhs something, that is not of the 76 days. They have stated that 76 days, only 76 days of overdue. They have
This
stated.
amount is due.
My lord.
This amount is due. What is due? Court cannot undertake that.
Yes, my lord, I am not on that.
You pay that. What is?
So I wouldn't say I'm just carrying the total dues because on the
But he's
total
That
dues.
is outstanding. That portion is the
Overdue.
overdue amount you can see.
Some amount, some days were given.
Petitioner, borrowers, prayer, textual prayer is at first. Learned panel consider appearing for the bank opposes the prayer. First time. Learned counsel for the petitioner, in variance with the prior terms, would submit that his client would pay the outstanding amount of rupees.
They have stated 8,18,570. But actually, that is not the amount.
But after it goes to your account only. 70. Within a period of 2 weeks.
I may be 1 month.
1 month.
Because I may be pardoned.
Within
NPA
within 2 fortnightly installed.
Yes.
With 2 fortnightly installments.
And the NPA, during that period, NPA be kept in abeyance.
No, my lord, here is a letter is a 30th January 2026.
Thereof also the remaining amount you have to make.
Yes, I am ready
He
to.
further submits that his client is ready and willing to pay whatever additional outstanding amount has accrued due since January 2026.
30th 1 2026.
That's what, January 20. This proposal is fair and reasonable. Next paragraph. In the above circumstances, petition is disposed of, permitting the petitioner to make payment of the entire money as indicated above, and also the amount that would be due
As on next. As on
this date. Within 3 fortnightly installments.
Yeah. And during that period, an NPA should.
During the said period, the NPA shall be treated as having been kept under suspended animation, subject to revival if undertaking is not adherent.
Date may be fixed for first installment at least. Usually this one.
Would accrue due on 15 days, which will be till the date.
My lord.
15 days, na?
15 days, a quarter.
Date may be
Which will be,
20th by
20th.
yes, 22nd of July.
26th. My lord, my only submission, my lord, kindly mention that I have submitted that the total dues is 46 lakhs. Only that thing.
Remananko calculation, maybe that is not the
Opposite petition containing that the total amount due as on this day is about 46 lakh rupees.
As on 11/4/2020.
As on
11/4/2020.
My lord, no.
However, this amount is somewhat disputed by the petitioner.
The actual amount to be paid by the petitioner.
What like?
None appears for the petitioner. All up to 4 weeks. Next.
On behalf of NPM is now next week.
All up to in the last week of July. You have to request.
Item E to the petitioner, you challenge the order of the land under tribunal. When the transfer order has been challenged, tribunal said that the competent authority is not signed for which the transfer order is. We are saying that placing at the page 119 is the circular transfer of non-gazetted railway employees master circular. The circular is annexed and as a annex 12, and let's say come to the page 119.
LPC should be issued immediately and signed by the state.
Very interestingly, when has got
all communications regarding transfer should be signed by a gazetted personnel officer with his name and designation.
Yes, it was done. Let me see this transfer. Let me see the page 37. 37, yes. Digambar Padi, Restaurant Personal Officer.
What is it? One pacho. Oh, very nice. Sit down. Do you want water? Give him water. Sit down. We'll call it off. I'm taking some water. Sit down. Should not have so much tension. Yes. Pass on.
In this case, I filed an IA on 3rd of July 2026, madam. That is not on record now. They have issued a sale notice for auctioning the mortgage property, and that has to take place on 23rd of this month.
Auction has taken.
No, 23rd they will proceed, madam.
You challenge before that here. Why here?
I only pay for a short time. I'll pay the amount they are agreeing to pay. They want the mediation with the bank, madam.
What mediation? You have taken money, you should pay back.
I'll pay, madam. Recently, 1.3 lakhs I have already paid again.
How much money you have borrowed?
12 lakhs, madam.
For a housing loan?
Yes, ma'am.
You pay, what is the amount due now?
11,27,000.
11,27,000. You pay 4 lakhs in pre-equalized installment. For equalized. And issue emergent notice. The Net Counsel for the petitioner draws our attention to IA number 6364 of 2026, supported by an affidavit wherein he seeks interim protection against the intended auctioning of the property for recovering the housing loan. First, he very fairly submits that his client will be making payment of rupees 4 lakh in 4 equalized fortnightly installments. First, this is very reasonable. First, in the above circumstances, the application having been favored, the bank is restrained from proceeding with the scheduled auction of the security property, subject to petitioner paying the outstanding a sum of rupees 4 lakh in 4 equalized fortnightly installments, first of them beginning on 22/7/2026. 23/7/2026. Failing which, not only interim protection with serving, but the petition runs risk of dismissal on that ground per se. Yes.
Let the recent IA number 12415 of 2026.
The number
12415 of 2026 may kindly be considered in this question. That is not on record, madam.
You will look into that.
My
Okay.
Under the petition challenge the order dated 10/6/2026 in Annex 5, my lord, that the prayer of the petitioner has been rejected only to give 6 months time to regularize. We have no, he has not prayed for not to give any installment, but he will pay the installment regularly.
How much money you had borrowed when? And what purpose?
15 lakhs, my lord, on 2024 as a housing loan, my lord.
Housing loan? Slowly. 15 lakh housing loan.
On
On
2024.
2024.
My lord, on January 2025, my lord, 25/1/2025.
How many installments were fixed?
5 years, perhaps not. That is my lord, my humble beginning.
Our humble question you have to answer. How many installments were fixed? Of them, how many have remitted?
My lord, 5 years.
Huh?
It was to be repaid within 5 years.
How many installments? And what is the quantum? That will not say.
Quantum is my lord. I am not confirmed, but exactly, my lord.
Huh?
Some 13,000 or something. I am not correct, but my lord. Well,
So
35,000.
35,000. 69 to 50, it will be. What is the amount due, brother, as on today?
And that is my lord. Annex on my lord.
We are good. What annex? You tell the amount.
13,000 my lord. 13 lakhs. I'm going to
13 lakh.
13 lakhs, 96,000.
That is 14 lakhs.
59 man.
About 14 lakh.
14 lakhs. Up to
14 lakhs.
My Hon'Ble before loss, on 25 January 2026, he has been arrested in the criminal case.
Arrested?
My lord.
What criminal case?
My lord, that is my lord. I have annexed that the High Court order, my lord.
We are asking you.
My lord.
What criminal case? Murder, treason, theft, dacoity. What?
137 to 115 to 164 to D, 64 to M.
Yes, now you have to say what are those.
Well, that
We'll
is-
now compare it.
My lord, he has been arrested and in jail custody. Now he is released on interim bail for 2 months, my lord. During the jail custody, he has repaid the installment, not exact EMI, but some amount he has been paid to the concerned bank authorities. Now he only prayer to give him 6 months time to regularize the EMIs. Only 6 months time to regularize. Now he will be his interim bail period will lapse, my lord, today, my lord. He will surrender before the court, my lord, on tomorrow, my lord. But only 6 months Hon'Ble before losses. Only 6 months time can be given for regularize his EMI. He will not give any discount, my lord. Only he regular after 6 months. If he will give, he will regularize the total EMI. He will pay the total amount of the bank loan, my lord.
Interim bail is granted for what purpose?
Due to medical illness, my lord.
Medical.
He had heart problem and serious diabetes. He has been released on bail by this honorable court for 2 months, man. And today is the last date, man, for the interim bail. Tomorrow he will be will surrender before the
Wife and children are there.
children, my lord.
Wife and children are there. What children are doing?
One daughter has been married and daughter has not anything, my lord.
No. Now amount is 14 lakh.
But only 6 more times.
Repeating that mantra.
My lord.
14 lakh is paid.
My lord.
Now immediately within 1 month you pay 1/3 of the amount.
1/4.
1/4.
Within 2 months, 1/4, then regularize. Within 2 months.
The challenge is to the coercive proceedings of recovery of the petitioner borrowers from the petitioner borrower, whose interim bail is coming to an end in a day, and tomorrow he is going to surrender for custody. Bail being on the ground of, not linked on being on the ground of death. First, learned counsel for the petitioner very passionately submits that a citizen being jailed will not shed all his fundamental rights at the prison gate, and therefore regard being had to the extraordinary circumstances of confinement, his client should be protected from coercive recovery. Personal. He also tells us that petitioner would be paying 1/4 of the amount that is now quantified at about ₹14 lakh, which is a housing loan. Personal. This appears to be fair to us. Personal. In the above circumstances, issue emergency notice and interim order as brief. And interim matter, the bank is restrained from taking up any coercive proceeding, subject to petitioner paying 1/4 of the amount. That will be how much? 3.5. 3.5. Petitioner paying a sum of rupees 3,15,000 in 5 equalized fortnightly installments. Account from this day. After, filling which sides. Half.
Half installment after 2 months.
Huh? No, we don't take. We don't take it. The bank will take the matter to the apex court and the entire order will be stayed. Yes. Pass on, madam.
And since that prior to his transferring submitted repetition. I'm sorry, my lord, I'm not able to manage it. And that petition directly considered and rejected. And apart from this, the transport of the annexure 7.
Transfer, how many years of service he has put in? How many years your client has put in?
93.
Less than 2 years, my lord.
No.
At Hon'Ble, my lord.
He joined in
When were you
1993.
Huh? 93.
He joined in the post of DDA, on the assistant driver, in the year 6/4/1993.
6/4.
Yes. Then he transferred 99 to Titlagarh.
So 1 second. From 93 to 2023, how many years?
My lord?
2003, 2013, 2023. 30 years plus 3 years.
Yes.
What is that you want to transfer? Where?
My lord, he has transferred Hon'Ble to Titlagarh. The same district.
33 years he has put in service. You have squeezed him like anything for all the 3.5 decades above. And he is saying, don't transfer.
All India service, nobody is ready to go one place to another.
How can we forget the human elements in these matters?
That cannot.
For a person who has served, was there any misconduct on his part? No.
Yes.
At any point.
Then may I suggest one thing, my lord? Already he has submitted repetition, but he did not anything here.
Yeah.
Let's direct to the authority.
Then still consideration of representation and 2 weeks still unfavorable consideration. You will not disturb.
But already he's joined.
Disturb, my lord.
Already he's joined that place.
Joined.
Already they are joined.
Within 2 weeks you have to take the decision on the representation. Otherwise he will be restored to the earlier position. He's an employee, not your prisoner.
But tribunal reject on the ground that the authority didn't have power to issue that.
We'll agree with you now that he has made the representation. You have to consider the representation within 2 weeks. If you do not take a decision and inform him about the decision, then he shall be restored.
Because the pendency of the court, what I have said that.
The union government
with humble prayer, my lord, with humble prayer, I want to bring one fact before my lord.
You have given a representation.
No, my lord. I am a victim. Because
have you not given the representation?
Yes, my lord, they have rejected. They have rejected.
Yes, earlier representation. Yes,
my lord.
Before it was representation.
Within 4 years, my lord, within 4 years, I faced 4 transfers, but persons are continuing since 96, 97, December 2010, and November 2015, my lord, at Hon'Ble without any order of transfer. They have filed a counter before one tribunal and admitted that counter available at page 88 and 89 of my lord's brief, my lord. I have prepared a death chart, my lord.
Brother Paddy, come to page 88.
Page 88.
S.K. Naik was appointed in 1994 November. J.K. SAHOO was appointed on 12/9/1996.
Yes.
J.K. Jojo was appointed on 18/9/97. U.K. Panda was appointed on 12/9/1996. Only he is discriminated. No problem. Come to 88.
All the persons have been transferred from one place to another. Yes. Since J.K. SAHOO, my lord said it's technical surgeon on 12/9/96 was posted to AC Sambalpur on 4/4/2020.
How many years the retention period?
3 years.
3 years. Within what period you are transferring?
1.5 years.
Less than 2 years.
But it's the same division. There is on same division.
What is the definition of transfer in your guidelines?
According to our guidelines.
You have to leave the one division and go to other division.
Yes. The transfer is one division to another division.
Where is the transfer guide? It defines transfer. You can't treat the easy driver.
No, my lord, yes, senior
now
section
it's
engineer.
got promotion and he is in promotional post.
I am a senior section engineer, man. And my difficulty is my mother is 80 years. He's staying at Bhubaneswar. He's a cardiac patient. As because my posting at Kontabaji, I am
How many children your mother has?
only son.
Only son.
I am only son and I am having only one daughter, my college going daughter. No other male member is there to take care of the whole.
How many transfers you have suffered during the service time period?
My lord, from 21 to 25, I have served with 4 transfers, my lord.
No, from 93, 64, 93. How many times you have been transferred?
My lord, since 93 to 21, I have no information. But as per the admission made in the counter, I have faced 4 transfers from 21 to 25, my lord.
Why, Mr. Padi, 4 transfers?
Two transfer, what type?
Will not stay the imbue. Will issue notice, but will not stay the imbue.
My lord.
My lord, what type?
Heard
What I am submitting, my lord?
Mr. Padi. Issue notice. Learned counsel Sri and so appears for the OP employee. First of all, he submits that the client has put in more than 33 years spotless service and obeyed all transfer orders. And therefore, the present transfer effected within 1.5 years of posting, retention period being 3 years, has been rightly set aside by the client.
That is maximum 3 years.
Yes, sir, retention period 3 years.
Maximum.
First, in view of the above, we are not inclined to grant any interim protection to the Indian public, which has to obey the impugned order of the tribunal, subject to outcome of the petition.
Man, obliged.
33 years, they have put in. You can't treat as the East India Company would treat the employees. Very often we are saying.
One full submission.
The pendency of the petition shall not come in the way of the petitioners considering the employees' representation dated.
That is not within us. He has submitted what the if you submitted this one.
Reconsidering employees' representation on merits. Okay.
May I one thing, basically in direction may be considered, but may direct that if you submit a repentance, something authority considers.
So you can't treat them, they are not slaves. They are all officials. You have to have what Shukraniti says.
The employees' ego also.
What is ego? What is the ego? 33 years he has put in. Shukraniti says, the king should treat his servants with love and affection and due respect and reverence. There is such a shloka, the Shukraniti, which Justice Rama Joyce has quoted in his services under the state. Very beautifully has quoted. I think the tradition of this country, not wherever you want, they are not your slaves. Yes.
My lords, item 11, appeal by the state, it is covered by my lord's judgment in Krishna Malik case, my lords. Lordship, there is a delay of 700 and
760. 760 per day, 20 rupees are fixed in all matters. We'll issue notice. All right. But it's covered by
Krishna Malik.
Challenge in this intra-court appeal is to the order of the learned single judge stated 18/1/2022, whereby the respondent employees WPC OAC number 1918 of 2018 having been favored, the following relief has been accorded to him. 6 and 7, 6 and 2. Next paragraph. Learned AGA appearing for the state and its functionaries vehemently submits that there are arguable points in the appeal, and therefore, in respect of the delay of 700 16 days, comma, an application in I number so and so, supported by affidavit had been preferred. First off. In matters like this, we have directed notice on the main matter and on the delay application, subject to appellants collectively paying a sum of collectively paying an amount of money calculated at the rate of ₹20 per day to the registry of this court for the first transfer. Next paragraph. In the above circumstances, issue notice on both main matter and delay application. If the appellants collectively pay the sum of money computed at the rate of ₹20 per day, that will be how much?
14,320.
This you can say the sum of 14,320 in the registry of this court within 3 weeks, failing which the application for condonation of dealing stands deemed to stand rejected, and as a consequence, the appeal as well.
Item 12, my lords, we have filed an application for substitution of the legal heirs, my lords. That is.
In the meantime, there are several cases are disposed of in the writ appeal, and so many cases disposed of. I covered in the writ appeal 15985/2024, man.
Show it to you, brother.
Employee of the WhatsApp employee, man.
My lords, this is covered by my lords.
Covered by judgment.
My lords,
Give it. This IA is filed by you.
My lords, IA is filed by
Your
me.
file.
For substitution. The respondent is appearing as sole legal heir.
You are appearing for
in my affidavit.
The respondent employee having passed away, comma, an application in IA number 573 of 2026 has been filed under Order 23, Rule 3 of CPC. 22
rule. Order 22, Rule 4.
Rule 4 of CPC 1908. Seeking to bring the LRs of the sole LR of the deceased. First of all, learned counsel Shri so and so submits that he is authorized to appear for the said LR, and therefore application be allowed with a direction to the appellants to amend the cost title. First off, we agree with this. First off, next paragraph. Learned counsel appearing for the sole respondent. Application is supported by the affidavits of the legal heir as well. Next paragraph. Learned counsel appearing for the legal heir of the respondent employee submits, and the learned AGA in all fairness does not dispute that the subject matter of this appeal is substantially similar to the one treated by this court in writ appeal number 1598 of 2024 between State of Orissa and others versus Basanti Das, heard and disposed of by this court by order dated 2/2026, negativing challenge of the kind. First off, it hardly needs to be stated that like cases should be decided alike, there being no apparent repugnancies. First off. Next part, in the above circumstances, this appeal fails, coupled with the direction to give effect to learned single judge's impugned order within an outer limit of 8 weeks. 8 weeks. Okay. 8 weeks. Next.
My lords, item 13, we have received the instructions. I'll file affidavit within 2-3 days.
My lord,
80,000 rupees. Now,
My lord. My lord, so the reason is given that he has not treated in referral hospitals,
that was
which
there.
is required under the guidelines. That is why I file
My-
affidavit.
that answer has been already answered in my writ petition.
You take it before some other bench. Don't mind.
My lord, they are trying to avoid your lordship's.
Yes. I am avoiding that. The last week of July. In the meanwhile, of affidavit may be filed. Okay.
Item 15, PWC CORAM 2026.
None appears for petitioner. These objections to be complied with within an outer limit of 4 weeks. Final. Next.
There is a defect pointed by the
My lord, item 15, my lord.
Yes.
My lord, item 15, I am in DC, my lord. My lord, the matter may be allowed to withdraw, my lord, permitted to withdraw. With the liberty to pursue the remedy in separate writ petition, my lord.
So that counsel appearing for the petitioner submits that there being several defects pointed out by the registry, is going to be permitted to withdraw the petition, is able to file a coherent petition.
No, my lord, he is pursuing his remedy in another writ petition, WPC 3911 of 26, my lord.
The pending WPC number?
3911 of 2026.
3911 of
2026. Ordered accordingly, WPC is to not.
Obliged, my lord, obliged, my lord.
Item 16, security 1 week time.
2 weeks for removing on request.
Item 17, PWC 10927116.
In this lesson, SR I am
remove defect.
Wrongly stated that receipt not filed. Receipt serving copy to government not filed, but only the Union Bank is the party minor.
Not
Government
government.
is not party minor. One first
Office objection not being sustainable is overruled. Yes.
Then, my lord, second defect, my lord, need eligible copy of annexures. But all annexures are not eligible, but only one, annexure 1.
All right, so we'll look into that. If they are legible to us, that is sufficient.
My lord, legible copy given, my lord. But annexure 1, half page, it is page 15 is not legible. Perhaps lots will visualize them. And other annexures are legible. Lots can see. Other annexures are legible. Only page
legible.
Auction is also failed.
Auction failed. Then we'll record that and dispose of it. Office objection relating to illegibility is also overruled. First term. Next paragraph. The petition prayer reads as under. Next paragraph. Learned panel counsel appearing for the bank, OP Bank. Union Bank submits that the auction, scheduled auction having failed, due to non-participation of the bidders, the substratum for the petition has withered away, and therefore petition needs to be disposed of accordingly. First term. ordered according to petition is this court of preserving liberty to the petitioner. If fresh auction is notified, liberty to the petitioner to approach the court or appropriate authority if and when fresh auction is notified. In that connection, all contentions are
earlier petitioner after this honorable court your lordship dispose of the writ petitioner directly to the petitioner giving liberty to approach the bank authority for a settlement of the issue. Petitioner approach the authority matter pursuant to lordship direction on the annexure 8 that that was kept pending. They have notified for auction. That auction failed. Annexure 8 is pending.
This order shall not come in the way of bank considering representation at annexure 8. On a war footing. Yes. Okay. Next.
No course.
No, we don't take it. Yeah. One appears for the petitioner. First note, compliance within office objection to be complied with within 2 weeks. Yes. Same order.
Item 20, BWC 184, 126.
Same.
Item 21.
Objections are complied first before the court. Okay.
Item 21.
Yeah.
WC 241.
No, first one, first three. No, please. This is for answer. Yes, that's all time. 2019 matter for admission.
No, readings complete.
No, why it is posted for admission? It has not come before the court earlier.
Yes, the number of times they have taken adjournment. It is for hearing, my lord. Only small care. Answer, my lord, whether I am entitled to third RSCP or not. That is the only point to be decided. I have given the chart here, but it will take at least 10 minutes.
At least 10 minutes or maximum 10 minutes?
Maximum 10 minutes.
Who
Within
appears
10
for the
minutes,
other side? Is it you? It takes only 10 minutes.
It will take only.
It has been considered by the learned tribunal, but raising only 2 points on this. By the learned senior advance, but only this simple point is whether he has availed 3 benefits or not, as per the MSCP scheme.
If he has already availed, it will not
Yes.
be. If he has not, then he will be.
Yes.
Well, according to you, 3 benefits are...
Yes, Your Lordship. In the counter, that has also been considered by the Honorable Tribunal as well. There is a, Your Lordship, may kindly see the findings. He could not show, the petitioner could not show any rule on the basis of which the tribunal could have considered his case. He has ever 3 benefits. What he is saying is he was previously in RPF constable, subsequently he was taken to CLA, chief legal assistant, law assistant, which is co-termed as chief legal assistant. So what he is trying to say is, because I am in railway, I am in one branch and I am transferred to another branch. So I am born in the cadre, so I should be given after I was appointed as a CLA, which the tribunal has not considered. They said that there are 2 wings of the same railway, so they should be treated as that this is the third RSP. So if he considers that, then there is no case.
3 RSCP has been granted is not in dispute.
No disputed.
But 1 is granted when he was shifted to another wing.
Yes, Lordship.
That is the only case. Should be reckoned or it is the question.
Lordship.
Is it correct?
No, that is not the case. Here is a case. He was a constable. Then he was promoted to Naik. Thereafter, he came by selection to the law assistant. According to this RSCP scheme, it came in 10/6/2009 with effect from 1/9/2008. The clause 5 says promotion and upgradation granted under ACP scheme in the past to those grades which now carry the same grade pay due to merger of the post recommended by 6th Pay Commission shall be ignored for the purpose of granting upgradation under modified ACP. So what has happened?
No, we have not understood what you are. Where is that?
That is clause 5 of the ACP scheme. So page 14. Annexure 1. I have prepared a condensed chart. If your lordship kindly come to that, your lordship can. So,
Was there such merger? Upgradation?
yes.
There was.
There was a merger.
When it was?
It was merged. I have given the chart. It was merged in 97, 10-10-97. 97.
Only.
Then that chart together.
What were the posts merged?
That Naik post was there prior to that. I have given the chart.
Like NAIK.
NAIK. That post merged with the head constable. And the scale of Naik was given to the constable.
Slowly. Merged in
10-10-97.
That is on. Merged in?
Merged in head constable.
Where is that order?
That 171, Railway Board establishment number 171/97. That is
Mr. Bhatti, please come to everything is illegible in this page number in page 14. Modified ACP scheme.
Yes.
Read para 5.
Promotions earned, the upgradations granted under the ACP scheme in the post of those grades.
In the past
of those grades, which now carry the same grade pay due to merger of pay scale upgradations of the post recommended by the 6th Pay Commission
shall be ignored
for the purpose of granting upgradation under the modified ACPs. But let's may come to the page 36, paragraph 6 of the counter filed with the tribunal. Page 36, yes. 36 eligible, 35, then 36, paragraph 6. May I read that? That in reply to the error made in paragraph 4.4 of the application, it is humbly submitted that the applicant was initially appointed the RPF constable on 24/4/1976. Subsequently, he was entered promotion to the post of RPF Naik on 21/5/1987. That is very important, man. In a scale of 95 to 49. That is his first promotion. Hence, it is hereby clear that from the date of promotion from 21/5/1997 to date of second promotion to the law stat, that is 25/4/1994, the applicant had enjoyed 7 years financial benefits attached to Naik. Later on his second promotion to the post of law stat, that is 25/4/1994, in the scale of progress such and such. In the 5th CPC and 9,300 such and such in second 6th CPC on regular measures as per the records available in his service record. As such, he has been granted third MACP, that is on 1/9/2008, on completion of 10 years from the date of his second promotion, or on completion of 30th years of service, 30th years from the date of his initial engagement, whichever is earlier in terms of para such and such, and etc. R/3.
How tribunal considered this aspect? How tribunal treated this aspect? Yes.
Paragraph 10, Lordship, in page 56.
But para 5 of the document at page 14 is not discussed by the tribunal.
The tribunal discussed in the paragraph 9 and 10, explaining all factual facts, taking the relevancy of all the records. Fine.
Kindly come to page 14.
1 second. Page 40. Yes.
1-4, para 5.
Para 5. Yes.
Sorry. You have read it already. We are just reminding you again, refreshing your memory. Go to 5. It says promotion granted on amalgamation shall be excluded while computing these benefits.
Was promoted in 87. Amalgam is in 97. So he cannot now come to this conclusion that because even though I've got benefit 87, again 97 I will.
This is dated what? Page 14 is dated?
Page 14 is dated 10/6/2009.
10/6/2009.
Previous page. It is page 12. Recommendation of the 6th Central Pay Commission, that is started from the letter of suggestion, that is a reliable guideline on 10/6/2009. The prospective impact, let's say, is considered.
No, it cannot be. It cannot be with prospective. Merely because the previous state of affairs is taken note of by the law, that does not become either retrospective or prospective.
But here is the case, he can't deny about the 87, then 96. The 87, 87 is in the one status, and 97 is in different status. So that's why this counter is there.
It is not same pay scale.
No. It depends. That's why I'm saying, 1 second.
There was no stagnation according to you.
Yes.
Was it a promotion? No, it is a merger.
No.
No,
It's a merger.
it's a merger.
What was the grade pay?
This 1 second.
Before merger, what was the grade pay? Yes, brother, what was your grade pay? Before merger?
That is 950, 1400.
Grade pay.
Yes. 21, 587. The scale of pay 950 to 1400.
950 to 1400.
Yes.
Now, after merger, what was this pay scale?
That is, let me explain.
What is the pay scale after post merger?
4500.
Then how are you going to have a benefit of class 5? Class 5 speaks of parity of grade pay.
Grade pay is 2000.
Then also you are not in. Grade pay should be same.
Yes.
Kindly see para 5.
Yes, that I
Only the grade pay which was attached to your post pre-merger and the grade pay attached to the new designation post-merger should be the same. Then you can draw the milk from paragraph 5, not otherwise.
94, from 94 to 97, I came to the law cadre in 97, 94. 97, there was merger. Till 97, the date 87, I was promoted to night. 87 to 97, they form a single class.
Question is not that. Maximum 3 are admissible.
Yes.
How 3 should be computed? It says, even if you have drawn 4, 1 you will be entitled to, provided your grade pay here and grade pay there are same, not otherwise.
Your Lordship,
I put that pay 2000 to 3000 TM.
So it is not 950 to 1400 yet.
Yes, 24.
There is nothing. Tribunal has, what tribunal has said, correctly.
Your Lordship, kindly come to this affidavit I have filed.
No, that makes no sense. So we are banking upon class 5. We are not convinced of class what affidavit we should do. Once if we grant such a benefit in violation of the conditions, it will have far-reaching financial consequences in the organization like railway. Railway is the biggest employer organization in the whole of the world. Indian Railway is the largest. So if we give one, it will open up floodgates of litigation. We will not do that. Heard.
Great pay, my lord.
No, it is already there. Great pay. I mentioned in the above para 4. The employee is knocking at the doors of report for assailing the Central Administrative Tribunal's order dated joint. So, whereby his OA number 275 of 2012 has been negatived on 31/8, wide order dated 21/8/2000, 31/8/2018. First term. Learned counsel appearing for the petitioner draws our attention to paragraph 5 of the MACP policy dated 10/6/2009. Relevant part whereof avails at page 14. First term. The said paragraph reads as under. Next paragraph. Next slide. Learned counsel submits that the promotions earned by his client by virtue of upgradation or otherwise is liable to be excluded while computing the number of benefits, number of event of benefit under the ECP scheme. And this having not been noticed by the tribunal, there is an error apparent on the face of the record warranting interference of the rate quality. Per contra, the DSG assisted by so appearing for the union points out that para 5 itself makes it clear that the exclusion is possible only when the grade pay prior to upgradation or merger and post merger is one and the same. First off, he points out that the grade pay earlier was 950 to 1800, whereas post merger it is how much?
It is
2000.
2000 to 3200.
3200. Though, first, next, having heard the net counsel for the parties and having perused the petition papers, we decline interest in the matter, broadly agreeing with the submission of the DSG in as much as for claiming the benefit of the kind under S3, the conditions stipulated therein have to be strictly complied with. First off, apparently, the condition stipulated in para 5 of the policy statement is not complied with. The grade base being different, pre-merger and post-merger. First off, although this aspect of the matter has not been satisfactorily dealt with by the tribunal in the reasoning part of the impugned order, that would not make much difference when the factors can be ascertained from the material produced on record. First off, in the above circumstances, the writ petition is liable to be dismissed and accordingly it is, courts having been made easy. Next. Yes.
This entering into the out of contempt. The merit of the case, my lord.
That here is a case, it is arising out of a contempt proceeding.
Let me say.
And जो party those who are made parties in person, they have already been superannuated.
You implead other parties now who are presently sitting on the chair, na? You implead them. We'll direct you now. You need not make application.
That's why already previously directed the court to implement the Steel Authority of India. He knows who is the chairman already. So
you give details who are the present incumbents of the officers.
I will supply the name. I have also taken the morning. I have instructed the concerned officers to collect the name. And he will.
Whether now structure of the contempt complaint itself will undergo change.
Yes.
What we suggest is, in the light of EMS Nambudripad versus so and so, you file a fresh complaint.
No,
and
my humble submission before the Lordship.
Understand password. Understand the law. You have structured your complaint keeping the officials who are now retired, superannuated. Now you have to supply a copy of the order to the present incumbents. And if they do not comply with the order, then you can come with a complaint, not otherwise. This is what affects
in this case. To disrespect my humble submission before Lordship, the order was passed by this court.
Passed by
this court. Granting tribunal allowed the exertion and direct to consider his case for compulsion. They have challenged. The High Court upheld the order and granted another 3 months time. Before that, my lord, he had filed a contempt petition there, and the contempt petition was dropped. So now,
dropped on what ground?
Dropped on merit.
They have said that not merit. My lord, they have said what they have said. The certificate which has been produced by this before the High Court has not. This certificate is not tally with that certificate, but the certificate already that has been dealt by the my lord, and death certificate and the certificate of issued by a doctor who declared he is dead. That has been decided by my lord, keeping in objection of him, my lord. Subsequently, on the same ground, they have rejected the case of the petitioner, which contempt was there. In contempt, court said that no, their regime is valid. So that is under challenge before my lord. Whether my lord's order has been violated or not, whether they have misinterpreted or not, that is. So I cannot file a separate petition. I may make a party, my lord.
But this finding will remain.
My lord?
This finding will remain is your.
Yeah, my lord.
You're right. What do you say about that finding?
Well, so far as
this court has dealt with the matter.
The tribunal directed to consider the case of the petitioner.
Correct.
And given certain time to consider the case.
Correct.
Thereafter, that order we have challenged before this honorable court.
Only 3 months extra.
This honorable court confirmed the order of the tribunal and extended the time for another 3 months.
Next order.
Thereafter, we passed the order on merit on considering his application.
What is the ground you have taken?
We have taken the ground that after 20 years we cannot provide the compassionate appointment. And another ground is that the death certificate which he has produced, that is a forged certificate. While considering the case of the petitioner, and he produced certain documents, my lord. The tribunal said that this case is coming under your scheme, so therefore you reconsider his case. And only the tribunal has directed for reconsideration. And we accordingly passed the order.
No, reconsideration means that was under the impression that he fits within the scheme.
If it is within the scheme, then you reconsider his case. So far as giving the compassionate appointment, my lord, we have to examine all the documents, materials.
When the death happened, according to you?
The death happened in 1998.
Give the date. Man will not die whole year. He dies on a particular day.
Yes, 1/3/1998.
Your lordship, see,
1/3/1998.
When this was death in harness,
Yes, my lord. His case is that he was suffered heart stroke.
We're asking you that it in harness. He died in the post.
Dying in the post.
Yes, in harness. So within what period he ought to have applied for compassionate appointment?
Compassionate
Who is that
appointment?
person? Widow, son, daughter?
The son has applied.
Son had applied.
Son has applied.
Has applied, that has not.
98, the death occurred in 1998.
All these points your lordship scored, your lordship kindly paste.
Let him complete that.
This court has already dealt, and regarding also the delay, they have said that your lordship, may I read that? Page 25.
25
of the order. Yes, ma'am, read petitions. As discussed above, the deceased employee had heart ailment and was being treated by company doctor in the company hospital. He was last treated there in 7/1/98, shortly before his death. It is not disputed that the deceased employee, while in native place, availing leave from company, died on 1/3/98. As rightly observed by the tribunal that the death is preordained and never come to notice. Since SAHOO, however, disputed the genuineness of death certificate issued by Dr. Hon'Ble on the ground that it was not issued much after the death of the father of the opposite party one on 24/3/98. He further contended that specialists of OG cannot give opinion on the cause of death, more particularly when the deceased employee is alleged to have died due to heart stroke. We are unable to accept this submission, firstly on ground that a doctor who had attended his patient at the time of death can issue a death certificate, even at the belated stage. Secondly, it qualified. Doctor can diagnosis the approximate cause of death.
So validity of the death certificate cannot be gone into at all because it had attained finality. Is your
my lord. Now they have said
it is
in the rejection order, they have said that death certificate on 1/3/98, on that day, how that death certificate has been issued and how that is a manipulated document. Now they have said. That is why my humble submission contract. And subsequently, regarding filing, the paragraph 8-9 of the writ petition, which was subsequently transferred to Lord Tribunal by the applicant, the opposite party applicant had categorically stated that immediately after death of father, he had submitted an application for compassionate, but the same was lost and could not be traced out. Thereafter, he submitted reference 2002. Thus, we had no delay approaching the authority for compassionate. The same authority have also filed counter affidavit to the said tribunal. However, have not denied the said averment. As such, following the doctrine of non-transfer, we are considered view. Consider to accept the contents of the opportunity that the application of compassionate appeal was filed before the authority.
How can you say it is a delay? It is fictitious. There is a finding by the coordinate bench that it is in time. There is finding that the certificate of death is genuine.
Death certificate issued by the doctor
is genuine.
Let your lordship kindly see what is the order passed by the tribunal.
Yeah.
First order. That the first order, your lordship kindly turn to.
Why first order?
Division bench order. The tribunal has directed that you reconsider his case and passed a reasoned order.
Reconsidered means that the facts on which findings have been recorded cannot be gone into.
We have gone into we have considered the death certificate produced by him death certificate, not the death certificate issued by the doctor, Lord, subsequently. But what is the death certificate, your lordship?
Regardless of the certificate, when he died.
But he died on 1/3/1990.
Leave it, the rest of the year.
The death certificate was issued on the same date.
All right, you forget the certificate. You admit that death has occurred.
We are examining the documents he has produced.
Do you dispute his death?
Yeah.
Do you dispute the death?
We are disputing the death certificate which has been issued. That is suspicious.
Certificate.
Yes, ma'am.
Do you dispute that his father died on particular date?
He has died, that we are not disputing.
Certificate is what?
Which is the date 1/3/1990.
Correct. 1/3/98 death is admitted.
Yes, ma'am.
Certificate is necessary to show that he died.
Rightly or wrongly,
dispute.
Rightly or wrongly, your lordship is interpreting that once the High Court has come to the finding.
Not only that you have admitted he died on 1/3.
1/3/98. We are not saying, Lord.
All right. Then suppose death certificate is not genuine. Whether that will.
But your lordship, can see the death certificate for a moment that
Why
is on
do you
record.
understand things, small
that,
things?
Lord, that is on record now. Your lordship,
Do you
Lord, we are not disputing the date of
the question?
Lord, the question is the document he has produced, my lord.
Is not genuine.
Is not genuine.
But that remains same.
1398.
On the death, right to apply for compassionate appointment arises.
Lord, the compassionate appointment he has applied for in 2002.
Correct.
I am not going disputing that, my lord. What your lordship is proposing, I am not disputing, lord. But it is a contempt petition was filed. We have, rightly or wrongly, we have passed the order. Rejected his application. Once you have rejected, Lord, we have rejected the application. He, instead of challenging that order, my lord, what he has done, he filed a contempt petition before the Honorable Tribunal. The Honorable Tribunal, on assessment of the materials on record, my lord, has come to the conclusion, no, contempt is not made out.
Why?
Lord, your lordship, can see the order.
No, we have seen now. You have argued that now.
Lord, the contempt is not being made out because at the time of scrutiny of the document which was produced before the authority, that is not genuine.
That you cannot say because the coordinate bench said genuine certificate.
Lord, our rule says that if either it may be a compassionate appointment or regular appointment, at the time of making the appointment, we have to verify the document. And thereafter we will give
even after High Court gives a finding, you will verify and you will arrive at a different finding.
Different finding we have not arrived at.
But you
that what we are saying, that the document he has produced, that is not genuine.
That is wrong.
That is not there.
That is wrong.
So therefore he filed a contempt petition. That instead of challenging that order, we have passed a region order. What the tribunal has directed. That tribunal has directed that you passed a region order. Consider his case and pass the reason order. That much.
That reason cannot be in variance with the reasoning of the coordinate bench.
Not the coordinate bench. What the Honorable Court has said. Your lordship, can for a moment. Not your lordship, kindly for a moment.
These are all 2 minutes cases. So
your lordship, kindly for a moment. The persons who have been added as a party, they are not there. They have been superannuated.
There need not be. Now this finding will set aside with liberty for him to approach the contempt, contempt jurisdiction. Right.
That your lordship, kindly hear for a moment.
What to hear?
Your lordship, can see that document. Your lordship, can see that document.
You have said it is not a genuine document.
It is not the ground of rejection is that whatever document he has produced, that is not genuine. Let your lordship, can see that document for a moment. I am showing to your lordship.
Why we cannot?
Lord, that is at page 40. At page 40, your lordship, kindly bear with me 1 minute. Your lordship, can see at page 40.
Yes.
Lord, the death certificate he has produced.
Yeah.
The lordship, can see date of death. 1398. And the document, the death certificate issued at 9:30, according to him, at night 9:30. This document was issued.
Yeah.
This death occurred. On the same death, how the death certificate can be issued on 1398?
That aspect has been discussed by the coordinate bench.
No, that has not been.
Kindly come.
That has not been discussed.
Even otherwise.
That has not been discussed.
Please.
Lord, the Honorable Court has said.
Why can't you understand law relating to compassionate appointment?
Lord, compassionate
appointment is not in dispute. You have not disputed the death. Right to apply for compassionate appointment arises on the death in harness. Death in harness is not in dispute.
Lord, in 98.
Correct.
Another ground of rejection is that we cannot afford the compassionate appointment because, my lord, there is a death benefit scheme. We have provided the benefit under the death benefit scheme.
How much you have given?
Lord, we have given more than 10 lakhs, Lord, on the date.
10 lakhs?
Yes, Lord. More than 10 lakhs on the date. On the date, the death occurred thereafter.
Is it true? Then if you have received 10 lakhs, then you...
Yes, Lord. We have given under the death benefit scheme.
There is an alternative, no?
See, the compassionate appointment is an exception to general restriction. Number 1, 96 of them. Number 2, it is intended to tie over the hardship that arises because of sudden death of the employee.
Yes, ma'am.
That hardship is not complied with because there is no hardship because they have put 10 lakh rupees into your pocket.
No, my lord. They have not mentioned anywhere.
Then we make an order that you produce
Let us take up this matter next week. I need I'll produce that.
I have said 10 lakhs we have paid.
We have not stated so that it is arising out of the contempt proceeding, my lord. So therefore, the show cause was filed challenging the order which you have passed against that contempt proceeding.
Still appearing for the OPs very vehemently.
I'll verify and file.
No, we'll record it.
We'll verify.
Let Bar Council take action.
Not because the death benefit scheme
very vehemently and repeatedly submits that on the death in
I'll verify and I'll file the counter.
No, of the concerned employee, the terminal benefits quantified at about rupees 10 lakh has been handed to the petitioner herein, and therefore the
exact amount I have not said. Exact amount.
It is recorded. You can see in your
exact amount your lordship. We have given what exact amount
you have said 10 lakhs.
Repeatedly said that.
Repeatedly you said 10 lakhs, more than 10 lakhs.
Give it by taking instruction.
Don't take all those
on taking
what you said, you have said we have recording.
We have given certain value.
Now you don't send
us. We'll file the affidavit.
Petitioner herein, and therefore the requirement of hardship is the question of hardship on account of sudden demise of the breadwinner
that after 20 years
would not arise. First off, learned counsel appearing for the petitioner submits that there is no such pleading from the side of OPs. First off, in view of the above, the OPs are directed to produce the authentic material to vouch the contention as to payment of rupees 10 lakh rupees. Payment
10 lakhs exactly I cannot say.
10 lakh more rupees, which was repeatedly asserted before this court on being questioned, on or before the next date of hearing, by filing the affidavit as well, failing which a heavy adverse inference may be drawn against the OPs. Also,
the OPs are not before your lordship. The OPs are not before your lordship.
Against the department. Also.
All the OPs have been superannuated from the beginning, I have said, and nobody is appeared.
You are taking unconscionable stand and you are making submission without the availability of pleadings. You said thrice that we have paid more than 10 lakh rupees. Everybody is sitting in the court. Now you want to change your version, which will not permit.
That may be a slip of tongue.
Will not permit.
I will take instruction and I will file the necessary affidavit.
We have made order based upon your submission. If you are agree, we can challenge it. Yes. Call this matter in the first week of August 2026. What let us?
First week of August.
Some date we have, first week.
And all the opposite parties are not before your lordship. You have fine. So from the beginning, I am saying that they are not the parties.
Sir, we have made order. We may be wrong also. You challenge our order.
That is not the question of challenging the order.
You have repeatedly said, asserted emotionally that we have paid more than 10 lakh rupees to the petitioner on the death of the employee.
We have paid. We have paid. The exact amount I cannot say.
Now you cannot change your version. Yes. Next.
Not next.
First week of August 2026. Yes.
Application 7198 has been filed.
Interim application.
A small amendment in the writ petition.
Proposed amendment.
What is the amendment?
Amendment is that the earlier in the writ petition, the order of the first order of the tribunal 594 of 2021 was omitted inadvertently. So now prayer is to
that order to be inserted.
17 July 23.
In place of paragraph 1 of the writ petition, the following may be inserted.
What do you say, brother?
No objection.
No objection.
Because the review order is not inserted.
The review order is also inserted.
Petitioner has moved application in IA number 7198 of 2026, submitted by affidavit seeking a leave of the court to amend the pleadings. First one, the proposed amendment reads as under. See that in that application it's saying. First one, learned counsel for the petitioner submits that the prayer for amendment is granted. If prayer for amendment is granted, no prejudice would be caused to the other side, in as much as nature and character of the case would not undergo any change. First one, learned counsel appearing for the OPs does not much oppose the application. First one, no objections are filed to the same. First one. Next paragraph. In our considered view, the proposed amendment would not change the nature of case, nor it would cause any prejudice to the other side. First one. On the contrary, amendment would facilitate the complete and final adjudication of all the issues involved in the case. First one. Next, in the above circumstances, application having been favored, leave to amend as sought for is accorded. First one, petitioner to amend the cost, petitioner to file the amended pleadings within 2 weeks. Okay.
25, my lord, in this case, my lord, I am for petitioner.
Is it? It is urgent in the morning.
Monday?
15 July.
15?
15. Fine, 15, because I will be there.
My lord, portion by notes order, they have given not complied.
That is how it.
May I please, my lord? My lord, here the husband of the petitioner had taken a business loan from OP number 1 in the year 2023, and the sanction loan amount was 35,50,000 only. And EMI was fixed to 48,000.
35 lakhs.
35,000, 50,000. And the EMI was fixed to 48,475 per month. And the husband of the petitioner have regularly paid 22 EMIs from the date 3 to 23.
How many EMIs were fixed?
23. And there are, my lord, because this loan amount was of, it is a term loan, my lord. Fact is that, my lord.
No, answer our question.
Yes, my lord.
How many installments were fixed?
That is, my lord. In sanction letter, I am giving it to my lord. I have already paid 23 installments.
We do not know.
Yes, my lord.
How many installments are that? How many installments?
Then I am appearing for the opposite party number 4.
Who pays for the bank?
My lord. Here, my lord, your worship kindly have a glance for
Do not have any glance.
No, no,
You are
yes.
asking a question.
Your
You
worship-
are the lender. How many installments were sanctioned? Fixed.
Regarding my lord, he claims, my lord, the loan was insured.
Answer, he will not answer.
The loan was insured, but wrongly, my loan was insured.
What is here was 23. No, they stated.
My lord, here.
Why are you not preparing for the bank?
No,
case?
my lord.
And you have deposited, oh, sorry, you have deposited 23.
You have created 23.
Yes,
But how many were prescribed?
I am prescribed to my lord, that is a term loan, my lord, for about 10 years. In between, my lord, fact is that, my lord, I have regularly paying the installments. In between, my husband, I am the co-guarantor here. My husband died on 28/11/2024. But my loan was insured then. Prior to this, my lord, and
insurance.
Insured.
Wrongly, my lord, he implemented opposite pattern of 4.
No. That is
Thereafter, as per lordship's direction, I supplied my lord the Bajaj Life Group, who is a proper insurance company, and he has filed interim application to implement the Bajaj as a party. That I is there, my lord, before lordship.
My lord, fact is that
Maybe allowed application to be allowed.
yes, my lord.
Your application to be allowed or not?
Yes,
You will allow that now.
yes, to implement the Bajaj Finance.
Yes, yes.
But that is there. Well, I have already filed the
That is
IA.
there. First, let him come, then only you can say.
Yes, my.
May I please, your lordship? My lord, there is no cause of action. We are not involved in the transaction. The opposite party number 4.
Whether loan was insured with you or not?
No, he is authorized officer. You are the authorized officer.
Yes, ma'am.
Oh, let me there. What is
My
that?
lord, I am for the insurance company who is wrongly implicated in the case. I am for ICICI
Prudential.
It is not the insurer.
It is not the insurance.
But my lord, that is their statement shows.
Then we'll not right now. We'll do that. We'll
That
let
is
it
their
come then.
statement shows in that bank statement account, my lord, annex
Bank will
1.
give one statement and you will be a sense of it.
Let my lord Bajaj Life Insurance come to my lord, related as a party. Thereafter, your lordship.
Why you give?
I have supplied the copy as per lordship direction 8.
No, we are asking.
No. Bank
Why
has-
did you give me? Why did you mislead him?
No, there is no misleading, my lord.
And how he implemented the ICICI?
11/1/23.
Show where is that where the bank
that is an annex to
rupees cost on the bank.
Annex.
Where show that who told you that the bank told you that
That is in their statement, bank
Very
account statement.
statement.
That annexure 1, page 10, my lord.
One second. Where is that?
That is 11/1/23, my lord.
ICICI Prudential Insurance.
Yes,
That is not the insurer.
but they have
They
made it.
have said that one.
Yes,
That is not the insured.
they have taken two times
Who gave this? Bank manager.
bank manager.
Let him pay 25,000 rupees.
No, your lordship can see.
Why did
No, ICICI Prudential, my lord, he opted for ICICI Prudential. That is why, my lord, the premium was, my lord, debited from his account. Again, my lord, on the same day, it was reverted back to his account and the Bajaj Life Insurance was, my lord, insured.
Why you did not inform him?
That is informed. He has executed the document, the insurance policy, my lord. The insurance policy with the Bajaj Life, he has, my lord, executed the document. Now he is saying that I don't know.
Where is that mentioned? In which of your document it is mentioned, Bajaj?
Well, I have not done file document. I have, as per lordship direction on 8/4/2026, I have supplied the document relating to Bajaj Life. That is why he implemented Bajaj Life as insurance company in my lord, interim application. That interim application yet to be, my lord, allowed by your lordship.
Policy details within 1 week.
Yes, my lord.
My lord, my humble submission.
With a cost of
Petitioner has moved an application in IA number so and so supported by affidavit seeking to array Bajaj Alliance.
Yes, ma'am.
With whom the loan in question has been insured. First off, the particulars of the insurer were directed to be furnished by the OP Bank, while our order dated so and so under the threat of cost of rupees 10,000. 10,000. First off. The bank having furnished the details, now the present application is moved. First off. Learned counsel appearing, panel counsel appearing from the bank very fairly submits that the implement be granted, the request for implement be granted, and they said insurer be arrayed as OP number.
Hey.
You are 4.
Yes.
OP number 4. After deleting the present OP number 4, ICICI Prudential. with which there is no vinculum juris. First, we agree. In the above circumstances, the application is allowed, semicolon. The present OP number 4, namely ICICI Prudential Insurance, is disarrayed, and in its stead, the
Newly added
Bajaj Alliance is permitted to be arrayed as OP number 4. First off, issue notice to OP number, emergent notice to OP number 4, returnable within 10 days. All right, any coercive action is being taken now?
No, but I have filed IA for that. That I should give you. IA number 2596, my lord.
Any coercive action has been initiated?
No, yet to be, not taken place.
Call in the second week of August 2026. Yes.
My IA should be IA number 2596 of 26. But no coercive action should be taken against me.
That's no action is taken as a.
But they at any time that.
In anticipation.
Are you taking action?
No.
Learned counsel appearing for the bank on being asked very fairly submits that till next date of hearing, no coercive action for recovery will be taken. Yes, first. But how can we take without the lawyer appearing for the petitioner? He says he is not well. He is moving a memo along with the medical certificate.
There are two judgments of full bench.
But in absence, how can we? Otherwise, you have seen, we are eager to decide this matter because hundreds of flat owners are suffering. Hundreds of flat owners.
Since last three occasions,
one man.
Since last 3 occasions, lordships have been hearing this, and on 2 occasions, once they have moved the Honorable Chief Justice also for the final.
All tactics we understand, but
once I have an IA for vacation of the interim. Let the main matter remain. It will be decided on the issue of law. But my interim application where the execution is in state, that needs to get us lordships. That is the only request for prayer. Otherwise, my lords, they would continue with their innovative tactics, and everyone would suffer. Small flat owners, my lords, for 700 square feet, one studio apartment type, everyone aspiring to have one in Puri.
in the morning, this matter was heard at length on the previous hearing dates. First off, it was adjourned to this day on the fervent request of learned advocate Sri so-and-so appearing for the petitioner. Petitioner. Very many arguments were submitted. Very many submissions were made as to the maintainability of the intra-court appeal of the kind. First off, we are not convinced that such an appeal does lie, there being a curtain of decisions in support of a review. First off, this day, learned counsel appearing for the petitioner did not appear. However, some junior colleague appeared and sought for time by moving a memo on health ground. First off. Therefore, we are constrained to grant a short adjournment in the matter. First off. Next paragraph. At this stage, learned counsel appearing for respondent number one. Respondent number one presses for vacating of the interim order granted by this bench or coordinate bench? Bench. By the coordinate bench, wide order dated 25/3/2025. First off, he rightly submits that when the maintainability of appeal itself is not demonstrated, there is no reason to continue the interim order. He submits that whatever interim order is in operation needs to be vacated at once. First off, he tells us that the issue of maintainability of the main matter is one of the relevant factors for granting the interim order. First off, be that as it may. We are not inclined to, first off, the interim order granted on 25/3/2025 was for a limited period, extension having not been granted. First off. Therefore, first off, we are not inclined to extend the interim order in the circumstances. First off. Next paragraph. Therefore, there is no warrant for examining the application filed by the respondent number one for vacating the interim order, when the said order has not been extended at all, since 25/3/2025. Call this matter in the fourth week of August 2026. Yes.
Item 27,
for the petitioner, in this case, the petitioner is the auction purchaser in a sale conducted by the recovery officer of the Deputy Tribunal Cuttack under the provisions of RDB Act and rules and second schedule of the income tax act. The recovery officer conducted the
what is the amount borrowed?
Borrower certificate amount 51 lakh.
51 lakh. What was it actually?
Borrower certificate of exact amount. I have to.
No, it's all right. Was it a business loan or a housing loan or what is that? The nature of the loan is
business loan.
Business loan.
The recovery certificate has been issued by the presiding officer after adjudication of the Section 19 petition, Section 19 application. Thereafter, recovery proceeding has been initiated. Recovery officer issued self-proclamation on 20 August 2025.
24th.
20 August 2025. I have in my date sheet available.
Self-proclamation. When whether the auction was held?
Auction was held on 29th August 2025. And the bids, I have declared a successful bidder for rupees 1,86,95,000. 1,86,95,000. Thereafter, the entire amount has been deposited on within 13/11/2025.
Within 3 months. As per rules, yeah, something like that. 8-4. Yeah.
Borrower has filed an interim application challenging the sale before the recovery officer, and I have filed an application for issuance of sale certificate. That has been considered by the recovery officer at Annexure 6.
What he has done?
He has done simple. The borrower has filed 2 appeals before the presiding officer before the issuance of sale certificate. Though there is no interim order, though the order filing of appeal is a defective appeal, neither statutory deposit has been made.
Where is the contesting?
Notice has been issued, but sufficient, they have not appeared.
They have not appeared. And today I have got the information, my lord, the excess money of the bidding amount against the borrower that has given and he has received it. Then lately I communicated he was not in the appeal. I also told that you just received.
We'll call this matter on 17th to give one more opportunity to the borrower.
17th?
23rd.
Prior to that.
Prior to that.
But the next one.
15th minute.
15th minute.
The OP number 345. OP number 345, who has been to be the borrowers for surety for guarantors, despite service, have chosen to remain absent. First up. Therefore, to give one more opportunity, call this matter on 7 of 2026, final.
17 minute. 17.
Next.
17.
Next. Yes.
But the issue is very short, madam. It is regarding VRS entitlement. From 2002, madam, has not been extended till date, madam. Despite, madam, the matter has been finally crystallized by the MD that this amount is required to be paid to you. Thereafter, SLP after that, madam, subsequently when government rejected, I approached this honorable court.
SLP dismissed?
Yes, madam. Well, kindly see my date, a short date that I have given to Lordship.
Serial number 29.
29, madam.
29. What is that? Who appears for the other side? Mr. Panda?
No, Mr. Mahanti is appearing. He is just coming, Lord. Just question.
Pass on.
Yes, come, Lord. That's it.
Please seek for a short adjournment, my lord. The council in arguing case is not available.
30. Item 30 is seeking adjournment, but my case is clear, my lord. It can be decided within 2 minutes. Because your lordships called for the information, the date of charge sheet. That was the lordship's order. if on the date of retirement any disciplinary proceeding or a criminal proceeding is pending, then the government is empowered to withhold the pensionary benefits. That is the second, Rule 7 of the.
That is how we have interpreted.
And pension rules. Yes.
Proviso.
And 66 says that in that event he will be given the provisional pension. One information was falling short, that is the date of charge sheet. My lord, your lords, I have prepared a date chart that the charge sheet has just recently been filed. He is not ready. He is not ready.
On this matter.
But it is in his favor. We have no case. That I am going to submit. It is because your lordship may see the date chart. And in the month of May 2026 only charge sheet was filed. My submission is if the charge sheet was not there, charges were not there, then there was no discipline, there was no proceeding.
Pendency will not.
Pendency will not there. The lordship have held other cases. এই চারটা পড়েলা কপি হতে দুইটা দিয়ে দিও এপটে আমি তাকে ওটা সলভ করে দেবো এটা ঠিক পছন্দ
Article 3 he retired. Everything is done subsequently. Not after 5 years. So the learned single judge is right in granting relief.
Right. That information was falling short, therefore this was being adjourned. We sought for the information come today. Yes. That there was no charge sheet.
Kindly be seated. The state and its officials are preferring this infra-court appeal for laying a challenge to another single judges order dated 4/1/2024, whereby respondent employees WPC number 20395 of 2021, having been favored, the following relief has been accorded. Go to the relief. Learned learned counsel appearing for the respondent employee vehemently opposes the appeal, making submission in justification of the impugned order and the reasoning on which the same has been constructed. First off, he tells that it has been a settled position of law that unless the disciplinary proceedings are pending or a criminal trial is halfway through, the pension payable to a retired employee cannot be withheld. First off. Next paragraph. Having heard the net counsel for the parties and having
Lordship may take note of that instruction and that our information.
Declines indulgence in the matter for the following reason. First off, the allegation was as to the respondent employee not filing the true and complete declaration of all movable and immovable assets in terms of Rule 21(4) of OGSC Rules 1959. First off, he retired on 31/3/2020 on attaining the age of superannuation. First off, the charge memo was served on the delinquent only on 36/2020. A copy whereof avails at Annexure 5. And the criminal case, wide vigilance PS case number 8 of 2017 was launched only on 31/1/2017. First off, the police after investigation have filed the charge sheet on 26/5/2026. First off, thus obviously, in terms of Rule 7, no disciplinary proceeding nor criminal proceeding was pending as of the date of the superannuation. First off, that being the factor on which the impugned judgment has been constructed, there is absolutely no warrant for interference at our end. First off, appeal is accordingly dismissed. with a coupled with a direction to give effect to the order of the learned single judge within an outer
8 weeks.
8 weeks. 8 weeks. What's made easy?
The 29.
Yes, 29. Yes, Mr. Monti.
29. Can you see that 2-page note may I given to you?
1992. Yes.
2-page note may I given to you, Lordship.
Note.
Yes, madam.
Reference I have given that.
Madam. Applicant claim of the present applicant for arrears salary incremental for the period 1/7/1990 to 31/12/1998 corresponding to VRS along with 18% interest from 21/1/2022 till actual payment. 22/1/2002 applicant to VRS as per VRS scheme with a stipulation the arrear would be released after sanction by government. 1/11/2002 arrear claim the applicant was crystallized by MD Salah Spring Mill as 4,10,357. That is page 69. Other staff and workers released from by VRS by 21/1/2002 are paid their salary areas based on judgment passed by this Honorable Court in 2 writ application. After
you take it before some other bench. Somebody saying that what to do is we should have this one for obvious reasons. Yes.
Section 31 has been addressed. Section 32. Use of things 7 of 125.
Date baby. Date baby.
The first week of yes.
8 is well of the before taking your losses to the impugned judgment passed by the Lord single judge. May I refresh my memory, my lord, that this is a case wherein I was working as.
Do you have jet chart with you?
Yes, yes.
I am also finding a note of submission.
Please give.
I have also written out of argument that also I have submitted matter.
What was the date of advertisement?
Date of advertisement, my lord, in 2017, 26/9/2017.
Man. How can that be?
Yes, my lord. This is a
election was in 2005.
That was for a different projects because this is a, my lord, Indian Council for Agricultural Research and Project Research. They used to give projects to the OUAT, and on that basis, OUAT used to advertise for post. Earlier, I was appointed as a scientist, my lord, in horticulture. The post for which my lord and friend filed the petition was for a senior scientist horticulture. That was, my lord, a separate advertisement.
So while in different project, you also applied for senior scientist.
My lord.
You applied for senior scientist. That's pursuant to what advertisement?
That is the advertisement, Lords of my kindly 26/9/2017. The advertisement is in page 72. It starts from page 71. Lords of my kindly see the page 72.
So,
posted this horticulture.
The case relates to appointment to the post of senior scientist.
Horticulture.
Senior scientist, horticulture.
Horticulture. Now, Lords of kindly come to my lord the essential qualification. The Lords have got it, my lord, page 72.
72.
Yes, ma'am.
PhD degree in the relevant subject.
Yes,
but from other.
Yes, madam. I have the MA in horticulture, my lord. MSc in horticulture. Then I did my PhD in botany, my lord. Now, lots of my kindly come, my lord, to my PhD certificate, which is page 79, my lord. Your Lordship got page 79, my lord.
79.
Yes, ma'am.
Yes.
This is on integrated nutrient management in African marigold, targeted erecta of higher yield and quality flower. This is a floriculture, my lord, topic. And I was awarded PhD, my lord. Now, Lordship, may kindly come and see, my lord, page 74, my lord. May kindly turn to page 74. 75 it is there, but page 75 may kindly also be seen. Page 75, Lordship, may kindly see the petitioner. That is respondent number 1, my lord. His PhD was PhD in agriculture. And the topic is there, my lord. Title of the topic is Site-Specific Nutrient Management of Elephant Fruit Yam. This is a tropical tuber crop, my lord. This is a agricultural science.
75 is for horticulture.
Yes. Page 75, your lordship has seen that, my lord. I am to inform you.
No, Soma Bandhapadhyay.
Yes, sir. Yes, ma'am. Lordship, may kindly see, I am to Vishwanath SAHOO. Dear sir, I am to inform you that on the recommendation of the Board of Examiners on the adjudication to understood thesis submitted by you, under notice thesis submitted by you.
Horticulture.
PhD in agriculture in horticulture.
Horticulture is also agriculture only.
Yes, my lord. These are agriculture is the mother subject, my lord.
These are all species.
Species, my lord. They are offshoot of that, my lord. One talks about the morphology, the other talks about the practical application of it. And lordship, may kindly see both the topics. One, I did it on floriculture. And lordship knows that PhD is always topic wise. PhD is not subject wise. May I explain, my lord? Tomorrow morning, my lord, if I go and pursue my PhD in IIT, though I have done my LLM, I can go and do my PhD in law, in law subject, interdisciplinary subject, and I may get a degree from the Information and Technology Department on artificial intelligence and law. But will I not be considered for if there is an advertisement which talks about PhD in law in relevant subject? Because it's a relevant subject which is important. The nomenclature was, in a relevant subject, you must have PhD. And the committee, selection committee, those who are there, present there, they found me suitable, my lord. With regard to that, the university has filed its, my lord, counter affidavit. The other day I placed that counter. If your lordships, my lord, desires, I'll place it once again. The university authorities found me suitable. And there is no challenge, my lord, of constitution of the selection committee, or there is no mala fide which was alleged against me or against the university. But Lord in single judge, only on the basis of that nomenclature, Lord in single judge, my lord, had come to a conclusion that relevant subject means concerned subject. Lord in single judge, my lord, had come to a conclusion that relevant subject means concerned subject, since you are not having
that concerned subject.
Therefore, you are not entitled to hold that post. May I take your losses, my lord, to the
who were the members of selection committee?
I have, with my lord,
any technical people?
Yes, yes, ma'am. Lordship, may kindly see the selection committee comprising of Vice Chancellor.
Where is that?
I have given in a dead chart, but it is also a part of the record, my lord.
Where is that record?
Lordship, may kindly come to page 101.
Go to 101.
I'm sorry, my lord. I think that's a page number.
Vice Chancellor,
my lord.
Co-opted members nominated by VC with consultation with state government.
From among the experts in the subject. Two subject experts, Secretary to Government Agriculture, An academician nominated by the Chancellor.
Secretary to Government Agriculture. Yes. The selection committee.
Committee on examining all the aspects of the candidates for the post of senior scientist horticulture recommended the candidates on the basis of the merit and suitability
For the post of senior scientist
horticulture.
Whether university has filed its pleadings.
Yes, please.
What is your stand?
Universities stand by its own procedure adopted by the selection committee. The university doesn't dispute so far as the appointment of the appellant is concerned.
Appointment means he is appointed, nobody can dispute. His credentials for appointment.
Well, his credentials for appointment was verified by the selection committee and he was found suitable. That your lordship will find page 13 of the counter affidavit. The entire selection committee proceeding is enclosed. Page 13, annexure C of the counter affidavit. That is internal page 13.
The page number is 111.
111. So far as my lords.
This number is
111, the one in its own.
The recommendation of the selection committee.
27 February 2018. No.
Yes, ma'am. Yes.
Annexure C.
Annexure
Yes,
C.
ma'am.
But you said page 13 of your counter.
That is internal page 13 of the counter. Now
This is the counter affidavit which has been filed, wherein, my lord, this is annexure.
And we have also filed an additional affidavit here before this honorable court in the appeal proceeding also, where we have we stand by the procedure and the recommendation by.
You are supporting his case.
Yes.
Additional affidavit is filed on?
Filed on. Not on 36/2025 by respondent number 2 and 3. At flag F, you will not guidance. Flag F.
Where, which paragraph you have stated?
We have enclosed the same affidavit, same selection committee proceeding, that is at annexure C by 2, internal page 10. And we have specifically stated, my lord, the lordship may.
Para 5.
Para 5.
Of the affidavit.
Madam.
How many members were there in the committee?
Committee, my lord, there were 5 members.
How many experts?
2 experts, my lord.
Subject expert?
2 subject experts. One is Dr. T. Maiti, Professor, Department of Vegetable Crops, College of Horticulture, and Dean PCKV, Manoharpur, Nadia, West Bengal. He is an expert. Then another one is Dr. Jitendra Singh, Professor, Department of Horticulture, College of Agriculture, IGKV, Raipur. He is an expert. And other members are Chancellor. One is Chancellor's nominee. He is also a professor and head of the Department Horticulture, Birsa Agriculture University, Ranchi. And 2 other members are, one is Commissioner cum Secretary to Government of Odisha, and other one is the Vice Chancellor himself.
When appointment was made?
Next one, page 18, 28 to 2018.
28 to 2018.
Yes.
When petition was, challenge was made?
(29/6, 2018).
In time. There is no delay, nothing. The candidate who was not selected the challenge, saying that the whatever qualification you possess, it is not a prescribed qualification.
They said it should have been a specified subject and not a relevant subject. Though the advertisement categorically states it must be a relevant subject. And Anand Single Judge has come to a conclusion that it should have been a specified subject, which was not a part of the advertisement.
Take out that portion of the judgment.
May I read, my lord? Also, may kindly, my lord, come to page 53, my lord. The fact which is not in dispute is that the pursuant to the advertisement. Lots of got page 53, my lord.
No, all that story may not necessarily come to the PhD part.
It is not disputed while the petitioner does have the required qualification along with the PhD in horticulture, which is the relevant subject. But opposite party number 3, though have the qualification as prescribed on para 5(2), but she does not have the PhD in the relevant subject. Since as provided in the advertisement,
more on relevant subject.
Next, my lord, I'm reading it out, my lord. Since as provided in the advertisement, the candidate is required to have PhD degree in the relevant subject, taking into account the name of the post, senior scientist horticulture, as per the considered view of the court, a candidate should have PhD degree in the subject horticulture. Then, my lord, may kindly come to 7.3. Placing reliance on the decision cited by law and counsel for the petitioner in case of so and so. This court is of the view that the petitioner having the PhD in the relevant subject, horticulture, it cannot be equated with the PhD of the opposite party number 3 in the subject botany as being a concerned subject.
Whether horticulture is part of botany or not?
Yes, ma'am.
Part of botany.
Yes, ma'am.
Study of plants.
Horticulture is the practical application of the botanical knowledge, my lord.
The botany is genus, horticulture is species. That's what you want.
That's okay.
How learned single judge comes to, how he overcomes expert opinion?
That, my lord,
the reasoning?
That part, the learned single judge has not
discussed about that.
Only 7.4 he writes, in view of the clear prescription in the advertisement that the candidates who have PhD in the relevant subject, it is of the view that this court, that the opposite party number 3 does not have a PhD in terms of the advertisement. The stand taken by the opposite party university as well as opposite party number 3 that after participating in the selection process and becoming unsuccessful, petitioner is not permitted to challenge the selection and appointment is also not acceptable. In view of the said decision, petitioner has the locus standi to challenge.
Not only the petitioner came to know of your credentials for the first time. Whether all your credentials will be web hosted?
Yes, it was all.
Where is that?
It was all.
Where have you stated in the petition? Who are the applicants? What are everybody? Who are the applicants? Mr. Ratto, is there any such procedure?
No, I not giving you. But I have not come back to the entire that procedure. Notifying the your lordship's apprehensions are correct. If it would have been notified, it would have
They will know in that
yes,
time they
objective.
can. Otherwise, only after results are published, you will be able to know.
That apprehension of your lordship is correct. But then I don't think any procedure to that in that regards is there on record.
No proceeding, no pleading.
Nothing.
No document also.
Nothing is there, neither from the university nor from the
But how learned single judge discredits opinion of the expert in the light of apex court decision in DC Bailarappa?
Mr. Tripathi has completed, then I'll have my otherwise.
Yes, sir. Okay.
Kindly turn to page 71 of the paper.
71?
Yes. Lord, I'll just repeat, some kind of repetition may be there. Mr. Tripathi has said. Kindly excuse me to that.
You're always specific. You know that. But sometimes arguments overlap.
Lord, I'll be careful, my lord.
No, no, absolutely not.
Page 71, my lords may kindly see. Page 71, this advertisement. Lordship would kindly see serial number 3. The subject is senior scientist, post is horticulture.
Correct.
Single post. Now the essential qualification, Lordship may kindly see, as my learned friend has already read, PhD degree in relevant subject.
Correct.
Now I'll take your Lordship to the degrees obtained by the respective candidates, page 74, my lords may kindly see.
74?
Right. My PhD degree, I am a PhD holder in horticulture.
Correct.
Now kindly see the
March 14, 2016 in horticulture.
Horticulture.
Correct.
Now kindly see the appellant's PhD, page 79. Botany science. But you've got it.
Correct.
Now, with these credentials, these people participated in the selection process. Number one, very important aspect, probably my learned friends are missing out. Lakshmi, kindly, this is selection committee's recommendation, the consideration part. Your Lordship's apprehension is genuine to the effect expert opinion. But in the angle of expert opinion, there is no recommendation at all. But your Lordship will find in the selection committee's recommendation, there is a rather I will say fraud perpetrated there. In place of her qualification, instead of PhD botany, PhD horticulture was mentioned by the selection committee. Kindly see that. That is what is very. Kindly see. That is at page, page 108, my lords, may kindly see. This is a fraud played on the selection process altogether. It's a very important aspect, man. Kindly see page 108. Vishwanath Sahu, PhD in horticulture, my lords, kindly see. And this is the angle in which the selection committee recommended him, found him suitable. I'm sorry, Anita Mahanti, 108, serial number 5, Anita Mahanti, handwritten. It's in my humble opinion, this is a fraud in the selection process, as your Lordship will consider it. She was not having this qualification at all. The degree in MCA was the relevant subject for consideration. Para 21, page 20 of my note, kindly see. Para 21. As is evident from the advertisement. But you got it, man?
21.
Exactly at page 20. Of my written note of submission. Kindly see para 21. As is evident from the advertisement, applications were invited for filling up vacant posts in different subjects, including. Let's see, got it, man. I'm sorry. I'm so sorry.
Yes, no, we have got it.
As is evident from the advertisement, applications were invited for filling up vacancies post in different subjects, including post of lecturer in MCA. Advertisement requires postgraduate degree in relevant subject. The relevant subject would therefore, in the context of appointment to the post of lecturer, mean postgraduate degree in MCA. In our opinion, the appointment to the post of lecturer, master degree in mathematics is not the relevant subject. The advertisement requires master degree in relevant subject, not appropriate subject. In the present case, the board of appointment has not stated that graduate degree in mathematics is the relevant subject for MCA, but not in sum and substance. It is equivalent to a postgraduate degree in MCA for the reason that mathematics is one of the subjects taught in MCA. This is, in our opinion, was beyond the power of the board of appointment. Para 22. It shall not make any difference even if mathematics is taught in the Master of Computer Application course. And a single judge, in our opinion, gravely aid in upholding the contention of Ganpat and university that relevant subject would mean such of those subjects are offered in MCA courses.
If mathematics is stuck in a postgraduate course in commerce, a master degree in computer course would not mean relevant for appointment in mathematics or for that matter in MCA. There may be a situation in which master degree in MCA is differently constrained. In such a degree may be considered relevant, but it would be too much to say that a candidate having postgraduate degree in any of the subjects taught in MCA would make the holders of master degree in those subjects of holder of master degree in computer application and therefore eligible for appointment. Language of the advertisement is clear and explicit and doesn't admit any ambiguity, and hence it has to be given effect to. Since the appellant Ganpat did not have any master degree in computer application, in our opinion, he was not entitled to be considered for appointment as lecturer in MCA. We are aghast to see that when a candidate possessing master degree in MCA is available, the board of appointment has chosen an unqualified and ineligible person for appointment in that subject. Its recommendations are therefore illegal and invalid. The natural corollary therefore is that the university acting on such recommendation and appointing Ganpat as a lecturer cannot be allowed to do so, and that the division bench of High Court was right in setting aside his appointment. In our opinion, an unqualified person cannot be appointed, whoever may be the recommendee. We are of the opinion that division bench of High Court was right in holding Ganpat was not eligible for appointment lecturer in master degree in computer application. Lord, this is one angle of the matter. Your Lordship has seen along Supreme Court. Then Your Lordship will see, I'll cite one more judgment. Kindly turn to page 22. This is in the question. If you are considering any other qualification other than the qualification you have advertised, but there may be candidates having same qualification. You should have specified that in the advertisement that the qualification having similar or the relevance or relevant subject will also be considered. There may be other eligible candidates who will come into the fray. Now today you are advertising horticulture with PhD degree with horticulture, that is the relevant subject, and you are considering a person PhD having botany. Now your Lordship may see 2011 Supreme Court, 2011 volume 12 Supreme Court, page 85, my Lord. That is at page para 29, my Lord. Page 29 of my note, my Lord. We have considered the entire matter in detail. In our opinion, it is paragraph. I'm so sorry, my Lord. Page 29, para 29.
You are right.
We have considered the entire matter in detail. In our opinion, it is too well settled to need any further reiteration that all appointments to public office has to be made in conformity with Article 14 of the Constitution of India. In other words, there must be no arbitrariness resulting from any undue favor shown to any candidate. Therefore, the selection process has to be conducted strictly in accordance with the stipulated selection procedure. Consequently, when a particular schedule is mentioned in the advertisement, the same has to be scrupulously maintained. There cannot be any relaxation in the terms and conditions of the advertisement unless such a power is specifically reserved. Such a power could be reserved in the relevant statutory rules.
For relaxation, if there is relaxation, if rules provide for relaxation and relaxation has been granted, then that should be mentioned in the advertisement itself.
But here
That's
also,
what court is saying. It's not a case of relaxation.
Here you are departing from your advertised norm. That's what I'm saying. You have advertised PhD in horticulture. There may be other candidates available in PhD botany. You could have indicated that in the advertisement. Without indicating that, you are considering a lone candidate for that and saying that the selection committee has considered it. What is the consideration is not before my lords. What is the subject experts consideration is not before my lords. How have they considered this expertise aspect, as your lordships are saying? It is not there before my lords, my lord. Your lordship will see in the selection committee there is nothing with except an abrupt sentence that we have considered. My lord, consideration there are judgment, 2011 volume 6 SEC, the meaning of the word consideration with due application of mind. That is what his judgment is also there, my lord, 2011 volume 6 SEC, LIC of India. LIC of India. 2011 volume 6 SEC. I'll give that citation.
That did not relate to recruitment process.
Yes, my lord, that is
the word consideration occurs in several domains.
That is regarding some appointment, my lord. I'll exactly judgment. I'll give it to your lordship, my lord. I'll give it that judgment to your lordship, my lord. My lord, next judgment I'll cite before my lords, my lord. 1993 SEC page 48. This is also on the question of relaxation. Subject to your lordship agrees with me that it's a departure from the
It may not arise.
If it is a departure from the advertised norm, then the selection committee should reserve the right in the advertisement itself that we have the right to consider it. Without reserving the right with a specific norm, advertising the advertisement, can you do that? That's the whole consideration point I am raising before my lords. Page 33, para 5, 1990, volume 3, SEC, page 48, para 5.
48.
Right.
93.
90, volume 3, SEC, page 48 is the judgment. Then para 5.
Para 5.
Yes, madam. In absence of statutory rules providing power of relaxation, advertisement must indicate that selection committee appointing authority has the power to relax the qualifications. Regarding working knowledge of Urdu, we do not agree with the High Court that said qualification is unjust. The college, being a Muslim minority institution, prescribed the said qualification for the post of principal is in conformity with the object of establishing the institution.
We are not on that paragraph right now.
I am sorry, ma'am. I am sorry.
Is it in page 45?
No, page 33, running page 33 of this note.
33?
Right, ma'am. I'm so sorry.
33 page.
Para 5 is there.
Para 5. The High Court.
It begins with 32.
Yes. No, 33, para 5, last but one paragraph. Page
the High Court has right.
No, we have that.
The High Court has rightly held. Lordship's rightly got.
No, on relaxation, law is well settled.
But I say that once you are departing from
relaxation,
but from horticulture to botany, it's a relaxation or departing from the advertisement. If you are departing,
relaxation is different. X subject is prescribed. They say, in the event the candidates belonging to X domain are not available, we will go to Y domain subjects. That is called relaxation.
But in my humble opinion, my
you feel that it's a case of relaxation as such?
Departing from norms of the advertisement, if you are departing or any kind of change you are making in the process of selection, then you must reserve that power. Because you have said horticulture, means you stick to horticulture. If there is any departure, then selection committee must reserve that right.
In other words, your case is that he does not belong to domain of horticulture.
Not at all, not at all. That in my writ petition, I have given a detailed description what is botany, what is horticulture. I have given a description in the writ petition. I have given the dictionary meaning of botany and dictionary meaning of horticulture. Botany is a science of plants. Horticulture is a subject covering cultivation of plants. I have given in my writ petition, kindly see, I have given a detailed description of that in my writ petition, my lord. In pleadings also it's available. Kindly see in the writ petition, my lord. May I request your lordship to see that part of my writ petition only. Kindly see my writ petition, my lord. Writ petition. I have given the details of that, my lord. Kindly see, my lord, kindly see page 62 of writ appeal, para 4. Page 62 of writ appeal, para 4.
Go to 60.
Running page 62 of writ appeal. My writ petition pleadings, my lord. Let's got it?
Yeah.
That the information sheet appended to advertisement dated 26/9/27 filed as Annexure 2 herein clause 5 deals with essential qualification. Clause 5.3 mandates PhD degree in the relevant subject as an essential qualification. Petitioner as well as OP number 3 herein were aspirants for the post of senior scientist horticulture. Needless to say, in order to be considered for appointment to the said post, PhD is the relevant subject, that is horticulture is a sine qua non. As mentioned above, the petitioner has completed his PhD in horticulture in 2016 and his certificate is annexed to the Annexure 3. But OP number 3, who has been given appointment to the aforesaid post, has done her PhD in another discipline, that is botany. Let alone being appointed to the post of senior scientist horticulture, the OP number 3 did not warrant consideration in as much as she did not possess the required qualification. It is up to mention here that botany and horticulture are two different streams and disciplines. While the former predominantly revolves around the study and learning of plants, the latter is more diversified in the nature and leans toward practice and implementation. Webster's Universal Dictionary defines botany as science of plants and horticulture as science of cultivating fruits, vegetables, flowers, and plants. Similarly, Definition of botany according to Oxford English Dictionary is the science which treats of plants, and botanist has been defined as one who studies botany. According to the same dictionary, horticulture means science of cultivating and managing gardens, including growing of flowers, fruits, and vegetables, and horticulturist is one who practices horticulture scientifically. That it is submitted that when opposite party university did not disclose anything regarding process of selection and appointment of number 3 to the aforesaid post, even after numerous requests were made by the petitioner, he was constrained to apply for the said information under RTA Act, but that too, marked Annexure 6 for kind perusal of the Honorable Court, that the appointment of number 3 to the post in question also violates existing qualification prescribed by Board of Management of the opposite party university for appointment to the post of associate professor, which prescribes PhD degree is the concerned subject as one of the essential qualifications. Now, your Lordship will see their guideline and advertisement. That is also not in conformity with each other. Their guideline, if your Lordship would see what it provides for. I'll request your Lordship to see their law governing the field. How the university can do like this, my Lord, only in order to favor someone. Kindly see the guideline, my Lord, as admitted by the university in their affidavit. Page 85, my Lords, may kindly see.
Of universities.
Own guideline for appointment of these posts. Kindly see page 85. Model qualification for, this is the university's document. They themselves admit this. PhD degree in the concerned subject. Associate professor equivalent. Serial number Roman 3. PhD degree in the concerned subject. That's their law. Must have PhD degree in the concerned subject. Now the appellant is trying to take advantage. In the advertisement, they are departing from their own regulation, saying the relevant subject. Now, question is,
pursuant to that advertisement,
we have participated. Question is now, even if we have participated, Mita Sahai, latest Supreme Court judgment, if your Lordship sees, Mita Sahai says, if there is a conflict between the regulation, law, and the advertisement, it is the regulation will prevail upon, not the advertisement. In that case, a candidate participating in the selection process admit the advertisement, not the illegality in it. That is what Mita Sahai says, Lord. Kindly see.
Just true. That has been the law since 1991.
Right. Mita Sahai did this. Lord, I have given along with my note, my Lord. Mita Sahai. That your Lordship will...
Legal position we have no.
Yes, Lord, I did not address that to your Lordship. Your Lordship are aware about this. But keeping this in view, now, Lord, when that I am coming back to the same export part, if your Lordship sees that in the recommendation there is an examination on the export angle, botany versus horticulture. Horticulture, then your Lordship may consider it that way. But in the recommendation, there is no consideration in the export angle. Nothing. Rather, I have shown the other part to your Lordship in the...
In PhD, what are the subjects you have been... you were assigned in PhD.
Sir, PhD is always
the package.
PhD is always a topic wise, my lord. When I do PhD, my lord, I take a topic.
What is
the topic, my lord?
Topic.
Also, may kindly come to my PhD thesis, my lord, which I have given 79.
Page 79.
Integrated nutrient management in African marigold. That's also, my lord, a flower crop. High yield and quality flower. Also, may kindly see who are under the guidance of Dr. C.R. Mahanti, who is Department of Floriculture.
You did the PhD in the Department of Floriculture.
Also, may kindly see.
He was your guide.
He was my guide.
Do you have your thesis with you?
Yes, my lord, I don't have one. So this is, may I, my lord, only answer some of the issues which have been raised by my lord and friend.
You were appointed earlier as what?
As a scientist in horticulture.
Scientist in horticulture?
Horticulture. That is what, my lord, I am continuing that from 2006 onwards. As a scientist in horticulture, I did my MSc in horticulture. And PhD, the subject I took.
But PhD in botany.
My lord, why I took PhD that botany, those days, Utkal University does not have a horticulture department.
That will not be.
Utkal University does not have a horticulture department. It has a botany department where I can do my interdisciplinary, my lord, study. This is allowed, my lord, since if I'm a law graduate, my lord, if I'm going for any...
So anybody has done PhD during that tenure is only in botany.
PhD.
There was no
horticulture department.
In that country?
No, in that Utkal University.
You may not have.
Utkal University. Because I was working in the OUAT, my lord, those days, in the horticulture department. So I took the NOC from them to pursue this particular
in-service PhD.
In-service PhD, my lord. On this particular...
What was the requirement when you were appointed in the department?
That was MSc in horticulture, my lord. Department was MSc in horticulture. I had that MSc in horticulture.
There was no issue.
There was no issue, man.
What Rathore says
the issue is, now my lord and friend is raising that you do not have a PhD in the relevant subject. My lord, the relevancy is not with regard to that specified subject. My lord and friend is getting confused, my lord, with regard to only one issue. That PhD is always topic-wise. I do my PhD on a particular topic. Maybe I am from a different discipline altogether. But I will be doing it from a topic. And my degree will be awarded on the basis of my topic, my lord. The PhD doctorate will be given on that. And my lord and friend was relying on these two judgments, my lord. One was appointment to the post of lecturer in MCA, computer application. That's a post of a lecturer.
Their mathematics cannot be equated.
Lecturer cannot be like
that.
That cannot be equated.
Not even in medicine.
My lord.
That is not the point. But
so, in case of PhD, my lord, there is a Kerala High Court judgment. I do not have, my lord, I can supply, my lord, the Kerala High Court judgment on the self-same issue, where it has been stated that it is only topic-wise. It cannot be looked from the subject-wise. And my lord and friend was also raising that issue that nothing was there before the committee. Lords may kindly come to page 106.
No, it is not that nothing was before the committee, but how the
committee did not have that act.
Not have.
Lords may kindly come to
nothing was there. It was there, it may be there.
The proceedings of
that angle of that approach.
This screening committee did everything. And thereafter only they placed those papers before the, my lord, the selection committee. That is a part of the university countermand. Page 106, man.
But admittedly, when two incumbents are there, one having the clear-cut PhD in horticulture, and the other one is in botany, then who is to be seen?
My lord, both have to be taken into account.
Who will decide?
That's the expert committee. That is what. That is what the expert committee has done that.
No. Many who have seen this advertisement with horticulture, many who were otherwise eligible under your heading itself might not have applied because you will consider only horticulture.
My lord, PhD in relevant subject.
If the advertisement could have been PhD in any subject of agriculture, then probably.
Lord,
any subject of agriculture, then covers everything.
May I put a question to myself, my lord?
You can put question to us also.
My lord, the PhD in relevant subject, the word relevancy has to be taken into consideration. Horticulture, you must have a topic, you must have a, my lord, subject, which will have a relevance with regard to horticulture. Therefore, the language is relevant. It is not, they could have, the advertisement could have been in the specified subject. The advertisement is relevant subject. It must be relevant. It must have a connection. That is what relevance means.
Always will have, even in medical science, there is arithmetics, there is engineering. For example, how heart function is a matter of is the medical engineering. So that relevance alone, some relevance will have.
One is the, my lord, the mother subject, the other one is just an offshoot.
Where is that? Horticulture is the absolute of botany.
My lord, agriculture.
No. Where is that?
Agriculture, botany, then my lord.
No, we can't say this. Where is that?
Yeah, on document, my lord, this is what the selection committee has looked into. Lord, so may kindly see. Therefore, I was reading out the 106, page 106. May I place, my lord? Proceedings of the screening committee for scrutinizing the application received for the post of senior scientist, AICRP, OUAT as per the advertisement dated 26/9/2017. Members present. The screening committee met on 14/11/2017 and onwards the scrutinization of the application received for different senior scientist posts. The committee examined the application meticulously on the basis of the requirement for the post of senior scientist as prescribed in the universe information sheet on the above advertisement as follows. Application and documents of the candidates for the post of senior scientist in 7 disciplines was taken by, and thereafter the career statement was prepared.
Advertisements are styled in such a way, even if Charles Darwin applies, he will not get selected. Because in which silo he will fit. He was basically a geologist, but he wrote books on evolutionary biology. He wrote books on ascent of man, evolution of man, and he wrote on botany, these things, in which he would have fit. We are not sure whether Darwin would have been selected under this advertisement. Why university did not specify which is the clear-cut subject required? All this, you create more problems to the aspirants, job aspirants. If your object is to create litigation and help the bar, it's very good. One way you will be called to the bar and you will be given Nobel Prize there. But point is, why you give scope for all these litigations? You could have been very specific. And many who were having this qualification, as Rato pointed out, might not have applied at all. Had they been in the fray, there would have been competition.
Wider competition.
And wider competition, and selection would have happened.
Once they say it is relevant subject, PhD in the relevant subject, that means the candidates having the relevant subject must have made their application, including Mr. Rath's client. Mr. Rath's client is also a PhD in agriculture.
In horticulture.
No, horticulture.
Your Lordship may kindly see that
Horticulture is
PhD in agriculture.
They are not
PhD in agriculture.
Absolutely.
Then horticulture.
No, it uses the word horticulture.
Lordship may kindly see.
Before the word horticulture, there is a date.
Lordship may kindly see. My lord, for a minute, my lord. I just
see page
74, your Lordship may kindly.
74, 75 may
One second. Kindly see
75 may
page.
kindly see.
This is the certificate.
Certificate 75.
Yes.
Let us see the certificate which
Page 74.
I had read.
Page 74, my lord. This is to certify that. Let's see. Page 74.
Vishwanath Sahu.
This is to certify that Vishwanath Sahu obtained the degree of Doctor of Philosophy so-and-so in horticulture in the university.
In horticulture. Please.
Why is it written agriculture?
It is written here.
That is a certificate. That is not that is a letter. The
Doctor of
certificate is
Philosophy
this.
bracketed agriculture in horticulture.
Yes. Doctor of Philosophy, agriculture in horticulture. Yes, agriculture in horticulture. Yes, specific subject is there.
Agriculture is everywhere.
Horticulture is there. Agriculture is everywhere.
The relevant subject is
Horticulture. And you show yours. Kindly see page 70, 79. Not even agriculture, botany science. Utkal University. This is of 2016, 2014. Mine of 2016.
Hard reserved.
The Lordship allows me.
Yes.
I'll just, since my learned friend has already cited some judgments, so far as essential and relevant qualifications are concerned, but I'm relying on some Supreme Court judgments, 2-3 judgments. So far as scope of interference by the Honorable Single Judge, basically, in a REIT proceeding, where the authorities have fixed the essential qualification and experts have assessed and given the appointment, particularly with respect to recruitment. This is the first
There
judgment.
are judgments on both the sides of the spectrum.
Yes.
The one which Mr. Ratho has now cited. Though mathematics is different from that subject is another. But the principle laid down is even court can scrutinize all these things. There is no matter which is an island of immunity from court scrutiny.
These are judgments of 2019. My learned senior has referred to the judgments of 2011. These are judgments of 2019. Lordship may refer to para 9.
In 2011 is not considered in this judgment.
No, 2011 has not been considered, but they have referred to very old judgments of 93, 94. And what is the ratio? If your Lordship may kindly see para 9. The essential qualifications for appointment to a post are for the employer to decide. The employer may prescribe additional or desirable qualifications, including any grant of preference. It is the employer who is best. Para 9, man. Para 9. May I place it once again?
Yes.
Essential qualifications for appointment to the post.
To decide. Employer may prescribe additional or desirable because the employer will best suited to decide. Court cannot lay down the conditions of eligibility. All right, that's all right. Questions of equivalence will also fall outside the domain of judicial review.
This is important. If the language of the advertisement and the rules are clear, the court cannot sit in judgment over the same. If there is an ambiguity in the advertisement or it is contrary to any rules or law, the matter has to go back to the appointing authority after the appropriate orders to the proceeding in accordance with law. In no case can the court in the garb of judicial review sit in the chair of the appointing authority to decide what is the best for the employer and interpret the conditions of the advertisement contrary to the plain language. My lord, another judgment. Case of Anit Kumar Das, the Lordship may glance. These judgments are of 2021. 2021, volume 12, SCC, page 80, para 17.3. The Lordship may kindly see. Para 17.3. Thus, as held by this court in the aforesaid
Page number?
At a page, is SCC page. Lord, 17. No. In fact, it is page 19. Page 7, para 17.3. 17.3. Last but second page. 17.3.
You're right. Thus it begins, thus not?
Yes, Mal. Thus, as held by this court in the aforesaid decision, it is for the employer to determine and decide the relevancy and suitability of the qualification for any post, and it is not for the courts to consider and assess. A greater latitude is permitted by the courts for the employer to prescribe qualification for any post. There is a rationale behind it. Qualifications are prescribed keeping in view the need and the interest of an institution or an industry or an establishment, as the case may be. The courts are not fit instruments to assess expediency or advisability or utility of such prescription of qualification. However, at the same time,
no, this is a prescription of the qualification.
Yes.
That is not the case. He is not on prescription. Now, a particular qualification is prescribed. Whether the candidates in the fray answer it or not is the question. No, always it is for the employer to prescribe which qualification is the potential employee should possess, because he knows the requirement.
Yes, they can also decide the relevancy and the suitability. That is what
they decide it.
Yes.
No, not relevancy.
But that is what para 17.3.
Relevancy in the sense, not for assessing whether it is relevant or not. It is for prescribing a particular, for example, for driver's post. What should be the driving license? What kind of vehicle he should have driven? How many years? These are for the employer. But suppose if the employer says he should have been one of the pilots in Apollo, then we can challenge it. One can challenge it.
Yes, but
launching Apollo has nothing to do with driving of a 4-wheeler, 3-wheeler, 10-wheeler.
But here, Miller, the case is different. If as my lord, as it fell from my lord, that if we have prescribed Apollo and the requirement is for driver, then certainly he could have challenged it. He could have said, no, you cannot prescribe. You should have given any relevant subject or qualification which is requirement for the post of driver. Here, my lord, we have said relevant subject. Relevant subject has been assessed by the authority. What the petitioner is challenging, petitioner is saying, no, the person who has been selected, he is having the qualification of Apollo, whereas I have the qualification for driver. Instead of considering my eligibility, you have considered him as eligible and given him the appointment. Here the issue is otherwise. So now it is undisputed that the petitioner has been working in this institution as senior scientist with MSc in horticulture for last so many years, more than 8 years or more than 10 years, man. That there is no dispute. Now, so far as the qualification is concerned, it was assessed by the experts, and those experts are not from the institution. Those experts were called from outside. They are from the different universities. They are the subject experts in horticulture. And I can go to the extent of saying that there were in fact 3 experts, because 2 were expert and the other person who is D.K. Jha, professor of head of the department horticulture, Ranchi, the chancellor's nominee. He can also be termed as an expert because his subject, if your lordship will kindly see that page 13 of the counter affidavit, his subject is professor and head of the department horticulture, Birsa Agriculture University, Ranchi, chancellor's nominee. He is the chancellor's nominee, but he does have a subject in horticulture. He is the professor in the department of horticulture, and so far as other 2 professors are concerned, Dr. T. Maiti, Dr. Jitendra Singh, who were taken as expert, they are also the expert in the concerned subject of horticulture. Now, we have not advertised for the concerned subject. All that we have said that the advertisement is for the relevant subject. So the experts, they have applied their mind.
Similar cases are there with the university having this kind of qualification in the senior scientist post, either before or after.
Yes, one. There are many people, those who have been appointed
With
in the
botany,
university.
with botany as
Botany, in the horticulture, my lord department.
Where have you stated?
I have, my lord. I have filed an additional affidavit. Even details of that. An additional affidavit has been filed.
Saying,
Paragraph 10 of my additional affidavit dated 11/4/2025.
simply you have said. It's just in the discipline of horticulture in OUT, the majority of senior scientists, associate professors
And having PhD in botany.
are having PhD in botany.
And I have a list, my lord.
of those persons.
Those persons.
You have. I never see.
All their PhD botany.
Botany.
I have replied that. I have said in para 8 of my reply that the stand taken in para 10 of the additional affidavit that in discipline of horticulture in OUT, majority of senior scientists, associate professor are having PhD in botany is out and out false and misleading. I have replied that. At this juncture, it is up to submit that even if such a head is assertion is assumed, it is true for the sake of argument, though not admitted, the same cannot be held to be any meaning or significance in the context of terms and conditions reflected in the advertisement. But nobody knows what was their advertisement.
No, he has given the qualification also.
But he has given the qualification, but the advertisement pursuant to which they were appointed is not before this honorable court. I have disputed this. This is my affidavit reply para 8. Dated 30th of June 20. Or 28th of June 20. I'm sorry, 28th of June 2025.
May I bring to lots of notice, my lord, only one small paragraph, page 21 of the judgment, my lord. Page 21, may kindly be seen.
Now, what reasoning learned single judge have given to overcome expert opinion?
But expert aspect was, since there was nothing in the recommendation, proceeding of the selection committee, Honorable Single Judge has not dealt with that. Because Honorable Single Judge was dealing with the proceeding of the selection committee. Proceedings of the selection committee, your lordship will find there is no whisper about this expert aspect opinion. There is nothing. If it would have been there, then it would have been up for the Honorable Single Judge to deal with. And on the contrary, the rules and advertisement are distinct, completely not contradicting each other. The rule says concerned subject, advertisement is relevant subject. Now they are trying to take advantage of the wrong committed in the advertisement.
That, my lord.
So Mitasai comes into play. So the whole thing, the university should now rethink about this.
For a minute, my lord, may kindly come to page.
Kindly see para 20, my lord, 2022, volume 11, SCC, para 20.
No, my lord, if such
One
is
second,
the,
Mr. Das, let me complete.
if such is the case, then the petitioner could have challenged the advertisement from the very beginning. After
That is what
participating in the process of
That
selection.
is what Mitasai replies.
2022?
2022, volume 11, SCC, page 392, para 20. I have only one copy, my lord, so kindly accommodate. Kindly see para 20. The advertisement issued by the appellant. How does it?
Different page. and that relevant features.
I've given one more.
You have another?
Yes.
Give.
The advertisement issued by the appellant, para 20. The advertisements issued by the appellant mentioned that DACP scheme would be applicable for the recruits. However, it is a settled principle of service jurisprudence that in the event of
It is a conflict between rule and advertisement.
Concerned. So your advertisement should have been for the concerned subject. Instead, you are using the word relevant in order to favor someone. To take a wider angle of it, kindly see this judgment. Accept the not then kindly see one more judgment, my lord. One request, my lord. Page 76 of my note, my lord. Para 17. Just say this one. Page 76 of my note, para 17. This is Mitra Sai. However, we must differentiate. This is my written note of submission, running page 76, para 17.
No, here today you have given a compilation, not that.
Well, that is there. 2019-20 SEC, page 17, starts from page 64 of my written note. (2019-20) SEC, page 17.
For the proposition?
That I'm saying that we accept the advertisement. If advertisement and rules are advertisement is illegal, then we do not accept the illegality. We might have participated in the selection process.
Correct.
But we do not accept the illegality therein.
That's right, sir.
Now, in the context, your regulation says concerned, your advertisement said relevant. In that case, concerned will be prevail upon. Concerned means horticulture, not the relevant subject. Kindly see para 17. However, we must differentiate from this principle in so far as the candidate, by agreeing to participate in the selection process, only accept the prescribed procedure and not the illegality in it. In a situation where candidate alleges misconstruction of statutory rules and discriminating consequences arising therefrom, the same cannot be condoned merely because a candidate has taken part in it. The constitutional scheme is sacrosanct and its violation in any manner is impermissible.
There is no estoppel.
And Article 14 comes into play. You have deprived lot many candidates having botany.
May be permitted by not only to page 21 of the judgment, may kindly be said.
21 of which judgment?
The writ appeal, my lord, page 21.
Impugned judgment?
Yes, impugned judgment.
Para 4.2.
It is contended that since malafide has been attributed against such action of the selection committee, such a decision of the selection committee is not required to be interpreted by this court in exercise of its extended jurisdiction. It is also contended that the word relevant subject so appeared in para 4.4.0 of the UGC regulation was clarified by the UGC in the letter issued in the year 2015. In this said clarification, the word relevant subject as provided under para 4.4.0 was clarified as follows.
Where university itself has to undertake the equivalence or meaning of all these things.
Yes, it leaves it to the university. And my learned friend was relying upon my lord all the time that university has already adopted this. Lords may kindly come to page 83. Because my learned friend was relying on page 85. So therefore, I must read it from 83. Lords may kindly see. Consideration and approval of the model qualification procedure for evaluation of candidate for selection to the post of assistant professor, associate professor, professor and equivalent of different constituent college, research extension division under OUT. the qualification, requirement and selection procedure for selection of so and so approved by the academic council under resolution dated so and so was placed in the meeting of the board of management. The board of management under resolution dated so and so considered and approved the model qualification for the selection of teacher and its equivalent with the following remark. The provision and norms of the UGC ICAR guidelines vis-a-vis OUAT statute in this regard may be placed in the next meeting of the board of management in a tabular form. Further, the board resolved to continue with the existing system till necessary amendments in the relevant provision of the statutes are being made. Thereafter, the 4.40, these UGC regulations, my lord, clarifications came. Clarification clearly stated that relevant subject means that the university has to do that. And thereafter, my lord, there are several other advertisements which have come, even from the All India Agricultural Research Board. They have given advertisement. They also put that relevant subject.
That I have enclosed to my affidavit filed before this Hon'Ble Court.
Additional affidavit or
Yes,
affidavit?
yes, additional affidavit, which your lordship have already gone through. There also I have enclosed all the advertisement. And if your
Of
lordship,
the Indian Council for Agricultural Research.
and if your lordship will look at the advertisement, what was the post? If your lordship may kindly have a glance to annexure 2, page 71. I think this is annexure 2 to the writ petition. Your lordship may kindly see.
Yes.
It's the advertisement.
26/9/2017.
Yes, ma'am. 26/9/2017. Advertisement. I'm just placing my lord.
Which paragraph?
At the top. Applications are invited from eligible candidates for recruitment to the following posts of senior scientist and junior scientist vacant in All India Coordinated Research Project under OUAT. The All India Coordinated Research Project, that is AICRP posts, are project-based and co-terminus to the funding of the ICAR. Then your lordship may kindly see the next page, page 72. Serial number 2. Nature of appointment. Project-based and co-terminus with the funding of the ICAR. The terms and conditions changed as per the funding agency, so and so, so and so. Now, my lord, what is the qualification which is prescribed by the ICAR? That we have given in our affidavit, which was filed before this Hon'Ble Court. That is at page 9 of that affidavit, which your lordship have already gone through. That affidavit was filed on 11/7/25. That is at flag.
My lord, what is the relevant paragraph?
Flag.
That additional affidavit.
Yes, my lord. At flag F.
What is the paragraph?
That paragraph.
This is what for you are reading this?
Because we have, my learned friend is referring to time and again that the guideline of OUAT says something and you are giving appointment referring to another guideline.
You say that is not a factor.
Yes.
What factors is the prescription by the funding agency?
Yes.
But if my learned friend is referring to ICAR, lordship would see just one document from my additional affidavit dated 28/6/25. 1 second, Mr. Das, don't disturb me. Don't disturb me, please. ICMR says, kindly see, my lord. Did the ICMR referred to by my learned friend, Mr. Das? Kindly see. ICMR says, 1 second, whether PhD botany is equivalent to PhD in horticulture in the state of agriculture university. ICMR, the funding agency. He says ICAR, the reference to which Mr. Das made, that they are the funding agency, they will decide it. Now kindly see, the question is, RTI questionnaire, whether PhD in botany is equivalent to PhD in horticulture in the state agriculture university. The reply is, PhD botany is not an approved discipline under BSMA. Then kindly see whether botany subject is being taught in horticulture subject in ICAR. Please see the link for detailed information on BSL syllabus, education, so and so, so and so. They say that botany, horticulture is not included in botany. ICMR says they are the institution to which they are referring to. But page 22 of my additional affidavit, I have got it under RTI Act.
Who said that?
The ICMR says, Milord.
Who? ICAR means?
ICMR is the funding agency of this scheme.
That's all right. Which authority has issued that plan?
Public information.
Well, in the RTI, we have got this information from ICMR, which is the funding agency, reference to which was made by them. Mr. Das is referring to ICMR saying the ultimate authority is there.
Para 8 of
they are reading like this.
Para 8 of the affidavit, that there also I have enclosed
Not over here.
prescribed rule which the ICAR has prescribed. The relevant portion I have given. This is so far as the qualification for senior scientist. That is also I have given. It says doctoral degree in relevant subject, including relevant basic sciences with 8 years experience in the relevant subject as scientist and lecturer. That is what is only the reflection. The advertisement is the reflection of the rules prescribed by the ICA. And I did not refer to the judgment of SAHOO much because it is already referred in the Anit Kumar judgment. So I am not.
And this fraud part also your lordship may consider.
Yes. There's no contention, nothing. One word is not.
Fraud can be unraveled at any stage. Fraud can be unraveled by your lordship and it is whenever it comes to your lordship.
But without pleading.
Fraud is required to be pleaded, but on record it is there. On record. But when
even
fraud is required to be pleaded. But I know that, with great respect, my lord. But fraud on the face of it is there before my lords kindly see. I did not plead it. On the face of record, their document. PhD in botany, but you are writing PhD in horticulture and considering it. Kindly consider this aspect. Grateful.
Thank you.
Open 33, read the page 8 side 3 of the okay?
In this case, your lordship,
yes,
my lord.
The respondent number 1, 9, 10, 11.
Let's see if opposite party number 4, my lord. Sorry, respondent number 4, Trilochan Jaina, was opposite party number 3 in the court below, before the honorable single bench. My lord, he had died in 2019, not substituted. Honorable court took up the matter of the same day, disposed it up along with the appeal that he has filed. So that is one part. I have filed substitution, condonation of delay, and so also setting aside abatement. Notices were taken out.
I don't have an objection because it has to be hard on merit.
That application will allow. All separate applications you have filed.
My lord, they are flagged, your lordship. C, D, and E.
Separate applications.
So I'm hearing for 1 and 9.
Who is dead in this?
Trilochan Jaina, respondent 4, my lord.
Respondent number 4. Trilochan Jaina. Having died, 3 applications have been moved. Each supported by separate affidavit.
Died before filing of the writ petition, your lordship. Writ petition.
Before institution of the writ petition itself.
Yes.
Then Supreme Court says, if a party dies pendent lite, Order 22, Rule 4.
Sir.
If party was dead much before institution of the original proceeding, then application for impleadment. Anyway, since they are saying they are agreeable, one application.
That is the maintainability of the writ petition.
Not delay in filing the LR application, semicolon. Other application seeks an order for setting aside the petition. That question will not arise. Petition itself was not filed. And another for bringing the LR of the deceased. How many?
5. 4.
4 LRs of the deceased.
How many LRs?
4A to 4E, na?
5 LRs.
5.
On record. First one. Ideally speaking, in a circumstance like this, the application for impleadment ought to have been filed. since the provisions of Order 22 are not invocable, of CPC 9 are not invocable, since the death occurred prior to institution of the original proceeding. First one, be that as it may. First one, next paragraph. Learned advocates appearing for the other side do not much contest the applications in question. First one, it is nobody's case that these persons are not the LRs of the deceased Jena. First one, their implement would otherwise facilitate due and final adjudication of the list brought before the court. First one, in the above circumstance, all these applications are allowed. Second, delay in filing the LR application is condoned. First one, however, the question of abatement would not arise since death occurred prior to institution of the writ petition. First, the LR application having been favored, LRs of OP number 4, respondent 4 are permitted to be brought on record. First, the appellant to amend the cost title and file an amended petition.
Amended cost title.
File amended cost title.
Consolidated cost title.
Consolidated cost title within 2 weeks.
The thing is, here not Honorable has appeared. He appeared to the court. Since he had not appeared here, the LRs may be noticed. I don't know.
LRs were noticed. That is how they are here.
No, this for substitution, not the appeal.
Substitution is allowed now.
No, you appeared for the LR.
No, sir.
He is appearing
I appeared appellant. For the LRs, Mr.
I am appearing for
Sir, is it-
4A to 4D.
They said LR. 4A to
4D.
4D are represented by 3 sides. 4E.
E is a.
A to D is all right. E is
So notice has to go there.
Yes.
notice had gone, sir.
Huh?
No,
Notice had gone.
substitution notice, not appeal.
Substitute and notice, they were not notified.
It was gone. It had gone.
From here.
Substitution notice had gone.
See,
Substitution notice had gone.
issued on the yes.
Substitution notice had gone.
They are sufficient. 4E remains unrepresented despite service offer. As per the submission made at the bar.
I will file within a week. Consolidated lordship may fix a date in the end of July possible.
Post this matter, immediately after consolidated cost title is filed.
Yes.
Only this. Leave it.
We have to
We have to use that judgment also going to dictate. Nah.
But can be posted Miller to a date with.
Stage operating. They had made a mention in lordship. Normally, covered the award pastor case covered. Their notes are allowed listed method. So can I pray for tomorrow news?
Thank you.